Considering the urgency of a matter,
Uh.
the matter was listed for admission here today. That reservation matter, but it was not listed. So I thought it proper.
My lord, in this matter, I have objected. A series is going on before the court number 30. And in his presence, I mentioned there to be taken up that this matter before the with the series matter.
Okay.
And he was not objective to that. My lord, unfortunately, my lord, unfortunately, on 1st of February, this matter was listed before your lordship. Inadvertently, my lord, not with the series, but here. My lord, on that day, I was on accommodation. And and it could not be placed that the series is pending before the court number 13.
Well, there is no series
Kindly,
pending.
kindly. Let
Well,
me
this
finish.
is a stay order where for the
No,
past
no.
1 year.
Is this matter before this court?
No, yes, this matter was before this court.
No, no. Is it before this court
Not
today?
today, my
No,
lord.
not today.
Not
No,
today.
Lordship
Not
has
listed.
fixed it up as agreed by the parties, seeing the urgency because our prayer
Now,
is.
where this matter is listed?
No, it is not listed today.
My lord,
That is the reason I
kindly,
mentioned.
kindly.
Ah.
My lord, when it was fixed on 7th,
Where is that order that this has been directed to be listed along with the series?
my lord,
There is no order.
I mentioned it by filing mention memo
Okay.
as before the court number 13. My lord, then my lord, when your lordship before this court on 1st of February it was listed, it was fixed on 7th.
He was not
But the
present.
series was is listed on 28th. My lord, then my lord, I informed the registry. After information, the registry has taken the consent of the Chief Justice and placed the matter along with the 30, before the court number 13. My lord, I inform him he is
My lord,
opposing that, my lord.
my lord, it's
My lord, this is
it's not a
parity,
question. My lord,
parity deserved, my lord.
my lord, one thing I want to say, this is not a case for parity for the simple.
No, no. There, see, what I could understand is there is a direction to list it on 7 to 2023.
Yes.
Generally, when matter is fixed, it is listed.
Yes.
So let me verify why this is not
Listed,
listed.
because
If there is a direction
in
from the
this case,
Honorable Chief Justice, then it will go
But
to
that
the
I don't know. He informed me yesterday night when I asked him that raised. I don't
because
know.
there must be some reason. Otherwise, generally,
My lord,
this matter
it
is
is on
fixed.
his application. My lord, what has happened?
Okay, we'll verify. We'll
Yes,
verify
ma'am.
that.
Because my stay order is not giving me the
My,
money to-
my
and
lord,
they, in fact, your lordship.
No, no,
what-
that not
Yes.
today. Let us see what. Yes, Silva.
oblige, my lord.
Victim of item 48. Ali, agenda matter
Item number
48.
today's list.
Yes, sir.
Just a minute. Why you want an adjournment?
I may file affidavit, but it's my
Which for the petitioner?
I'm-
What kind of affidavit you want to file?
non-compliance with the order.
You are for the respondent or petitioner.
I'm petitioner.
So that is a case for non-compliance of specific order. This is pending for
They have-
2016.
Yes, Lord, but they have filed an affidavit, and I'm may file affidavit.
Wait for your turn. Wait for your turn.
May I please, Your Lord, to 45 explanation, item number 27, Your Lord.
27.
But there has been no contact with the petitioner for a long time. So I have to
Item number.
27.
Now what do you want?
But I want to adjourn this matter for a week.
Why?
Lordship, there has been no contact with the petitioner for a long time. So I have to seek some instruction whether they have got any relief in the
What is the prayer?
raise for a regular absorption in the post and for pay of the regular salary. He has not paid the regular salary.
Wait for some time. Let us see if we can find an effective one.
All right. Okay.
May I please, your lord. Similar prayer, lordship, item number 1, admission.
Item number?
1 of admission.
Yes,
And
what
two.
is your prayer?
Lordship, I am also unable to contact with my client. Lordship.
Not contact will decide on merit. Yes. It's a 2015 matter.
Item number
40.
243.
What is the IA for? Prior stance rejected. Yes, next.
Tomorrow, the
Bench three. Like, who is taking motion? Senior bench.
court number five.
Huh?
Court number five is in division.
Two is also taken.
Only this bench is taking bench three.
Court number two.
So they are in division.
No, court number two is not different bench.
Not
Single
vision.
bench.
Code number two is single.
Mark. Single.
Code.
I got item number 47. Password was
Why?
because my senior is not there.
We'll see. Wait for your turn.
Eight. Actually, medical cost for the state. Due to some medical emergency, without. 50. Right.
Have you taken consent from the other side? Wait for it. Yes, Mr.
Number 51. Complied.
With contempt this lordship
Okay.
on last occasion directing take instruction. I have received. Okay. Right.
We requested
Yes.
you, na?
That is
Mm. In terms of this court's earlier order dated, so and so, so and so. MS MD Bora, Learned Counsel for the
Co-person department.
Cooperation Department submits that the interest as directed under this court's order dated, so and so, Agarwal to side level, has already been paid. Accordingly, she has submitted the statement showing submitted a document showing the statement of payment. Full stop. Mr. Munir, Learned Counsel for the petitioner, submits that in view of such submitted as order has already been complied with. Accordingly, the contempt petition stands closed.
I'm deeply obliged.
much of
Also, may keep my other part.
Huh?
It's it.
Okay, the communication furnished shall be made a part of this record, part of this contempt case and marked as document X. A copy also be furnished.
Already
Oh,
done. Deeply obliged.
may I please?
yes,
Malab, item number 4, Millard. The petitioner has got the tip.
Mr. Mondal, Learned Counsel for the petitioner submits that the relief sought for has already been granted to the petitioner and accordingly the matter has become infructuous. In view of such submission, writ petition stands closed. Interim order, if any, stands vacated.
Developed. May I please?
Yes.
Lordship, the recommendation item number 29 and 30.
Hmm.
Lordship, first is Lordship, request for promotion.
Hmm.
Next, petitioner went on retirement,
Hmm.
then retirement, next case is for retirement benefit.
Hmm.
Mentioned.
Hmm.
Then the respondent denied my service after retirement.
Hmm.
Then petitioner again approached by filing a repetition Lordship 6354. Lordship,
What is the grievance of 6454?
Lordship, their denial, Lordship. I already 35 years.
Okay. What is the method?
Lordship, pension matter. Lordship, I am paying Lordship to
List that matter along with this.
along with
Learned Counsel for the petitioner submits that another writ petition pending between the petitioner and the respondent in these two writ petitions. Another writ petition is pending.
Lordship 6345
Being WPC
6345
6345
2020.
2023. And accordingly placed that for proper adjudication, the said matter also be tagged along with these two writ petitions. Full stop. Prayer is not objected by the Learned State Councils. Accordingly, same stands allowed. Registry to list this two writ petition along with WPC so and so after 2 weeks.
May I pray for fixing that?
On given date. February.
May I please, Lordship?
Yes.
I get to mention for this thing contempt petition.
Go to the senior bench. Yes.
small prayer, my lord, in item number 36, my lord. I can file a reply, my lord, against the affidavit filed by the GMC or
35 is a series.
36, my lord. 36 and 37 is the same, my lord. My 36 is the leading case, my lord.
But
And we have
what
to find-
about Mr. Kotoki?
Kotoki, my lord, I have one of his junior, I have informed, my lord. I need to reply, my lord. He also cannot proceed.
I'm very correct.
You also need to.
Yes.
Okay, Mr. Chia, we are learned counsel for the. Have you taken consent from the GMC?
GMC, my lord, I need to reply, my lord.
Understand. There is a
I'll inform right now.
wait for some time. We'll adjourn. Let the GMC. That is basic minimum requirement information. Yes.
The morning hour, what happened, my lord?
Okay. So you wait for some time. You ask your junior to be here.
All right. Get to you.
Yes.
My instructor after getting interim order, get for the investigation. FIR or to sign page.
Why have we have granted an interim in a rejected case? Let us see.
So because he has 2-year minor daughter, no one is there to confirm.
She is there.
CD is there, madam. In fact, earlier it was rejected, but not elaborately, madam.
Not elaborately. Huh?
Yes, just I have seen, madam. But here, madam, as per but the postmortem report, cause of death is not certain. Just sent for viscera is sent for FSL.
Hmm.
FSL report come. FSL said there is no poison was detected in the metabolism, no poison. Subsequently, again, IO requested the same doctor who is giving the postmortem, madam. This is the FSL report. Now, again from the hospital, Naga hospital, after perusal of the FSL report as well as the he has done the PM. Now, final cause of death is cardiorespiratory failure. That is the final. Now,
Hmm.
now fact is that there are other co-accused also, the brothers of the husband and all this. They have all said that the statement. Why she take poison, we don't know. Something is there. Sometimes husband may rebuke and all this there. Why she? But poison is not there.
Not there.
All the witnesses of husband all are saying that why she take poison, we don't know. But poison is not there. So that is
Heard, Mr. Ahmed, learned counsel for the petitioner. Learned counsel for the petitioner. Earlier, this court, after perusal of the case diary and considering the statement of the neighbor and other witnesses, refused to grant privilege of pre-arrest bail. Thereafter, the petitioner again approached this court by filing the present application. This court, under its order dated
14, 12,
under its order dated 18 when
14, 12,
14/12/2023, granted interim protection to the petitioner. And in terms of the aforesaid order dated 14/12/2023, the petitioner had appeared before the IO and recorded his statement. In the meantime, the investigation further proceeded. The investigating officer, the case diary is produced today. The case diary reflects that in the meantime, sufficient progress has been made by the investigating authority. The investigating authority obtained
FSL report
FSL report,
as well as final opinion of postmortem.
FSL report, which reveals absence of
Poison.
poison. Full stop. On the basis of such FSL report, final opinion has also been given by the doctor who conducted the postmortem upon the body of the victim. Full stop. The final opinion also to the effect that the death was due to
Cardiorespiratory failure.
cardiorespiratory failure. Considering the above considering the above material, and also considering that the petitioner had in the meantime cooperated with the investigation, the interim order passed on 14/12/2023 is made absolute with the following conditions. No need to appear, but you write it that other conditions, hamper, temper, and abnormal. Dispose them. Case diary be returned. The writ petition is pending. Writ petitions, two petitions, no? This writ petition is pending since the year 2011. Full stop. Due to non-appearance of the counsel for the writ petitions, writ petition, the writ petition was dismissed for non-prosecution by this court under its order dated 12/6/2023. However, subsequently, the aforesaid dismissal order was recalled in IA miscase number 77/2023. Accordingly, the file was restored to its accordingly, the writ petition was restored to its original file. First, none appears for the petitioner on call today. Yes, Argu. Okay, after some time. Yes,
Lord, my senior is not feel bad.
contempt is between us and the contemner. Where is the order? This is the son's senior, sir, Anuel. Call Mr. Nayak. Wait for some time. Yes,
May I please refer this also for the family, Mr. Tina to explain.
what is their stand in affidavit?
Didn't reply.
What reply will you file? There is a direction to place your case before the DLC. Okay? You say that there is a contempt, it was not placed before the DLC. Now they file an affidavit, it was placed before the DLC, and the recommendation of the DLC is annexed and part of writ petition, a part of the contempt petition.
And they have some pillars on the recommended.
That is a new course of action. You challenge this. We are giving you liberty. You are not adjudicating your right here. There is a direction that you do this way. Court has not said that you appoint him after. Court says place this matter before the next DLC. Okay. Now DLC's matter was placed before the DLC. DLC has taken a decision negating your claim. Now file a writ petition. Why this should be kept pending since 2000? This meeting is of 2017. We are in 2024. Hard. You are Mr.
Here you go.
J.
Here you go.
Gogoi. Learned Counsel. Yes, madam.
I am on behalf of Dana.
Why you need your senior for this? We will not record your name. None appears for that response. If you cannot assist us, we will not recognize your presence. By the present application, the present application is filed alleging willful and deliberate violation of order dated 15/12/2015 passed in WPC number 4671/2015. The operative portion and a direction issued in the aforesaid order is quoted herein below, page 9, black mark to black mark. Full stop. The respondent Sumit Satwan, Sailava, page 16. Sumit Satwan, IAS, Deputy Commissioner, North Lakhimpur, Assam, has filed an affidavit in opposition and has annexed the district level committee meeting of Lakhimpur district for appointment on compassionate ground held on 24/2/2017 in the conference hall of the Deputy Commissioner Lakhimpur. In the said meeting, the case of the petitioner na 24. The claim of the petitioner was rejected on the ground that his claim has, the proposal has spent its force. Full stop. In that view of the matter, in the considered opinion of this court, the order has duly been complied with. Full stop. Accordingly, the contempt petition stands closed. It is needless to say that petitioner shall always be at liberty to assail the decision made by the DLC if petitioner, if it is so advised. Full stop. Yes. Yes, Mr. Sutia. Home and Political Department, then Superintendent of Police. Direction is specific. Okay.
Yes.
Direction is that the retirement and pensionary benefit of the petitioner should be released to the petitioner at the earliest.
But not really.
So according to him, not released. So we have instruction. This matter is pending since 2017. Might have been paid, that's why not here. Anyway, the present contempt petition is filed assailing and alleging deliberate disobedience of the judgment and order dated 28/9/2016 passed by this court in WPC 3205 of 2015. By the aforesaid order, this court has issued a specific direction that the retirement and pensionary benefit of the petitioner should be released at the earliest. Full stop. None appears for the petitioner on call. Full stop. In the aforesaid backdrop, this court has requested Mr. Torun Sutia, learned additional senior government advocate, to assist this court and obtain an instruction whether in the meantime the aforesaid order has been complied with. Full stop. Mr. Sutia, in his usual fairness, has accepted such request of this court and submits that he will obtain the necessary instruction by the next date fixed. Full stop. Accordingly, list this matter on
After 2 weeks.
give a date after 2 weeks. 1st of March 2024. Full stop. Registry to list this case showing name of Mr. T.C.
Yes.
Sutia, learned additional senior.
Item number 47.
Item number
49.
49. None appears for the petitioner on call. Present contempt petition has been filed alleging willful and deliberate violation of this court's order dated order dated 26/4/2016, passed in WPC number 1724 of 2016. By the aforesaid order, a direction was issued to the respondent department / employer of the petitioner to conclude the pending departmental proceeding within a period of 2 months from date of receipt of a certified copy of the said order after following due process of law. When since 13/5/2009, the petitioner is not being represented by any counsel on 37/2023, on 24/7/2023, and on 16/10/2023. None appears for the petitioner when the matter is called today also. Accordingly, this contempt petition stands closed.
Okay.
51 given.
May please the Lord.
Yes.
Here, what had happened, we are the bank employees and we were supposed to be reinstated by the respondent authorities, but till date has not been done. And it
Yes.
is so many years now. And they have not filed their
Where is
affidavit.
the,
One
where
of
is the,
them,
where is the order?
Lordship, at page number 91, Lordship can see the operative portion. It's page number 91 of the contempt application, paragraph 25. Lordship, I may read it. In view of the reason stated above, this court finds that the impugned orders dated 22/10/2009, terminating the services of 265 numbers of employees is arbitrary and accordingly set aside. The decision of Board of Directors dated so is also set aside. If the respondents decide to retrench, terminate the petitioner's services, they'll have to comply with 25F of the Act. The import of direction to comply with 25 Act requires the petitioners to be reinstated back into service, which should be done by the respondents at the
Yes,
earliest.
Musari.
Number 6,
Who is respondent number 3?
my lord, the Chief General Manager of NABARD.
Oh, no, she is not appearing in my case. My case is item number 55.
This matter is called 55. Musari.
These are all analogous matters.
Who is appearing on 55?
55, I'm there.
No, respondent.
Oh, yes. Respondents here are Secretary to the Government of Assam Cooperative, or then again Deputy Secretary, and then Registrar Cooperative Society.
Who is being represented by the board?
Board Lordship will find he is respondent number 5. Respondent number 5, in fact, had filed their affidavit.
What is
Others
the,
have not.
who is being represented by respondent number 5?
Mr. Assaf or someone had represented last time. Today he is not there.
This is a common judgment.
This is a common
Common
judgment
judgment.
for all.
Uh,
Only the respondents are different. I have not made NABARD as respondent.
NABARD is not necessary. Why
necessary.
should NABARD be?
In fact, he is appearing for NABARD.
You don't have any responsibility. It is basically the board.
Board.
Who is being represented by board?
Respondent number
In this
4,
case,
Chairman.
is Ananda Bhushan Das.
Chairman. And now he is replaced. Lordship will find new incumbents have come. Otherwise, service is complete.
Yes, call the
It has been pending since long, Lordship may,
Okay, all
order
the
for-
standing council cooperation department.
Lord.
We'll do something
after some time.
after some time.
Lord.
After some time, we'll take it.
Lord.
May please,
Yes,
property portion of the order, Lordship, page 11. Paragraph 5.
just a minute. Yes, who is representing the respondent?
Now, Lordship, respondent file one additional affidavit. On 2/8/2020.
What is their stand?
Lordship, now they have prepared, Lordship, one draft. Lordship,
Who is representing? They say that they have prepared a draft rule.
draft rule, Lordship, and send it to the personnel department. Lordship, that is page 45. Additional affidavit filed on, Lordship, 2/8.
Page 45. There is no continuous. page.
44 is the, Lordship, 44 is the letter, Lordship, forwarding letter.
So what do you say? Let us wait for some time. Okay. The present application is filed assailing willful and deliberate violation of this court's order dated 27/6/2019, passed in WPC 4425 of 2019. By the aforesaid order, this court directed the respondent authorities to examine the case of the petitioners for promotional avenues by making necessary amendments of the rules, as the respondents may deem fit. First of all, such exercise was directed to be undertaken as expeditiously possible, preferably within a period of 6 months from date of receipt of a certified copy of this order. Full stop. One affidavit has been filed by the Deputy Secretary of Labor Welfare Department, Dispur, Assam, on behalf of all the contemners / respondents, and a specific stand has been taken that in compliance of the order in question, a draft rule has been prepared. Draft rule has been prepared, and the said draft rule is also annexed with the affidavit as annexure 1. Full stop. However, none appears for the respondents contemners to apprise this court regarding present status of such draft rule, in as much as the affidavit was filed way back on which date?
I received copy 2/8/20.
On 2/8/2023. Stop. Considering that draft rule has already been prepared, the non-representation of the contemners is condoned today. However, condoned today and matter stands adjourned and be listed on give date after 3 weeks. 7th of March 2024. Full stop. If none appears on the next date, none appears for the respondents on next date, this court will be left with no option to call for personal appearance of the contemners to apprise this court regarding the present status of the compliance slash the acceptance not the status. Full stop. Please take it.
Applied.
None appears for the parties on call. The present application is filed willful and deliberate violation of this court's order dated 12/10/2020 passed in WPC 1036 of 2020. By the aforesaid order, a direction was issued directing the principal cum chief superintendent, Fakhruddin Ali Ahmed College and Hospital, and director, Directorate of Medical Education, Assam, to consider the case of the petitioner for appointment as medical record officer at Fakhruddin Ali Ahmed Medical College and Hospital, Borpeta, in terms of the recruitment exercise initiated by an advertisement dated 4/10/2017. Full stop. The entire exercise was directed to be carried out within a period of 6 weeks from date of the order. Full stop. Come on. It is, though no affidavit has been filed. Yes, who is for the health? Nobody is here. Though no affidavit has been filed, however, sick, s- speaking order dated 28/7/2023 is placed on record, which has been passed in terms of this court's order dated 12/10/2020. And speaking order was placed on record, which goes to show that yeah, it wasn't, a record as produced, speaking order of president, which goes to show that, for one of any qualified candidate, the entire selection process has been cancelled. An entire selection process of MRO at Fakhruddin Ali Ahmed Medical College and Hospital has been cancelled, and the Director of Medical Education Assam has further requested the hospital authority to re-advertise for the post of MRO at the earliest. Allow me to call somebody from health. DP Bora. DP Bora. In view of the above, in the considered opinion of this court, are you aware contempt petitions are being listed, name are shown?
No, in this case, Mr. D. Gugoi is appearing, Lordship. I will inform him,
Inform him.
Lordship.
We will have no option but to call for the personal appearance. His contempts are not being represented. 5960 here. 5960. 5960. Ito na, matapos. Complied.
It has always been complied, ma'am. There was no occasion for a contempt proceeding to be drawn. Now, what had happened was these people, my lord, they claim to be outsourced workers of the APDCL.
Where is the order?
My lord. If my lord takes up the contempt petition,
What is IA in
there are two IAs, my lord, that we had filed for dispensation of the personal appearance, for keeping that order at bay.
Where is that order?
The order of personal appearance, my lord,
Hmm.
is part of the IA. If my lord kindly takes up
Let us see first the order.
order, ma'am. Yes. The order is at page 13 of the contempt petition.
13.
Yes. After hearing learned counsels for the party,
Just a
non-
minute, just a minute. No, 13 is the something different. Contempt petition.
contempt petition.
Up to 14 is the prayer.
The copy that I have been.
Then 15 is the
It is an order dated 30th August 2009.
this is WPC writ petition. Where is the contempt petition?
Item number 61 is the
Okay. Writ petition is still pending or what?
still pending.
What is the issue there?
They claim to be outsourced workers. They say that the services have been interfered with.
Any interim order?
Yes,
Is
there
any
is an
interim
interim
order?
order. So, page 13 of the contempt.
Where is your affidavit?
Affidavit in the contempt petition, my lord. In the writ also we filed an affidavit, my lord. In
But
opposition.
where is the contempt
Yes,
affidavit?
yes.
No affidavit file in
There is
contempt.
an affidavit, my lord. So filed on 25th August 2020.
25th. Okay. Abhijit Sharma Burwa.
Yes,
Where is your stand?
my lord. Page para 5 of our affidavit. The opponent most specifically states that respondents and so and so have filed their affidavit in opposition, where a categorical stand has been taken that the writ petitioners number 1, contempt petitioner number 2, 2, 8, so and so, and were engaged by the AP digital authorities as outsourced workers for collections of bill.
None appears for the petitioner on call.
The contempt petition, my lord, is for a-
Okay. Not as a petitioner on call. An affidavit has been filed. This order, the present contempt petition is filed alleging willful and deliberate violation of this court's order dated 3/8/2019, passed in interim order of this court dated 30/8/2019, passed in WPC 6255 of 2019. Full stop. By the aforesaid order, it was provided that if the petitioners are serving as Sahayak in APDCL, their engagement as Sahayak shall not be terminated during pendency of the writ petition, and they shall be paid their remuneration. Full stop. An affidavit has been filed taking a specific stand that the petitioners were not serving as Sahayak in that.
3 of them were not serving.
Who's the respondent number?
But there are 9 petitioners.
9 petitioner, has taken a specific stand that paragraph 5, taking a stand that
Oh.
respondent, writ petitioner numbers 5, 6 and 7 were not engaged as Sahayak at any point of time. Full stop. It is a further stand that the writ petitioners numbers 3 and 9 had on their own volition offered their services with a sole objective of gaining experience which might aid them in future recruitment process. Full stop. So far relating to the respondent number, writ petitioner number 1, 2, 8 and 9. 1, 2, 8 and 9. 1, 2 and 9. A specific stand has been taken that their salaries, remunerations are being regularly paid, and accordingly, vouchers of payment has also been annexed. Full stop. Such contentions has not been refuted by the contempt petitioner / writ petitioner by way of any reply affidavit. Full stop. Reply affidavit. None appears for the petitioner on call. Considering the matter in entirety, this court is of the view that let the writ petition be taken up. Affidavit file,
Yes, my lord. In
writ petition is taken up.
on 2nd April 2021.
Writ petition be taken up for final determination. on merit by on 6th of March, in as much as the respondents has also filed their affidavit. So accordingly, list the writ petition being WPC 6255/2019 on 6th of March in the admission column.
My lord,
Along with this one,
my lord is closing the contempt.
no, we are not closing, close on the, let him be.
My lord,
He might have to say something.
I'm clear.
In view of such stand-in affidavit, though this court is of the prima facie view that no case of contempt is made out. However, this court is not inclined to close the same in absence of the learned counsel for the petition.
Deeply.
Yes, this is item number early hearing. Okay, Argu. What is the issue here? Now, was there any departmental proceeding?
No, my.
You have been dismissed under 311. Rule 10,
Yes, my.
311, Rule 10.
Yes.
What is the impugn order?
Look, case number 31.
Okay, where is the appellate judgment?
Look, case number 27.
When will you argue? Day after tomorrow? Punna diva. Why should you interfere? You have been convicted. What is the law? So, today can be the earliest date for hearing, isn't it?
Then, my lord. Get to.
No, no, that cannot be. Who is your senior?
Yes, but
No, have to give a date.
on.
Huh?
on that people.
Human method আছে. Huh? Okay, 12. একটু লেখা। The present interlocutory application is filed for early hearing of WPC number 5056 of 2015. Full stop. 15. Considers the statements made in the application. Full stop. Mr. R.M. Das, learned counsel for the respondents, Water Resources Department, and Mr. For the respondent number 6 has no objection for fixing the matter for fixing the matter for early hearing, fixing the matter for hearing. Rule has been issued.
Yes, my lord.
Huh?
Yes.
When rule issued?
Rule it, my lord. On 29 January.
Okay, full stop. Accordingly, the present IS stands allowed, full stop, registry is directed to list the connected writ petition being WPC 5056/2015 on 12th of February 2024. IS stands disposed of. Main case in view of the order passed in IA so and so. Let this matter be listed for hearing on 12th. Yes. Anita.
Yes, with your lordship. But the last petition, last one to petition to the petition, filed the affidavit in opposition, replied or the private respondent.
What affidavit in reply?
The private respondent to file their affidavit.
When?
Long back.
Then?
I-
Do you know what is the year of this writ petition?
I could not contact my flat for long back. If there was a fault on my part, also I could.
Pleadings are there. We'll decide on the basis of this pleading. Why do you need your client? Clients will not instruct you on law point. Facts are already there in the writ petition. So we'll proceed. That's all.
It may not be interested, but
Say that we'll dismiss it.
may I pray?
Huh? How many meters? 2 meters. One, two. Yes.
I'm not aware that other companies with that case, but
Uh-huh.
he is also engaged in the same case.
That's right. Yes, tell us. Who will argue? You are not even aware. Forget about the facts. You are not even aware that you have been disengaged.
Perhaps I may back.
Any interim order?
No, that
Wait for something. Wait for something. You are in both the cases, madam? You are in both the cases?
it's that.
No.
Yes.
Okay. None appears for the petitioner on call. None did. None did represent the petitioner when the matter was called on 18/9/2023. However, MS
And Kalita,
M. Kolita is present representing
at the PhD department.
representing the PHE department, and Mr. L. Mohan is present representing the respondent number 4. As none appears for the petitioner on call, the matter is dismissed for non-business.
Highly obliged, Lord.
Yes, Kolita.
Your Lordship, by the last order, Lordship, wanted me to appear in this matter because the department got amalgamated. So I got a petition So I haven't got the inspection as yet, but I have gone through the petition a lot.
Mm.
As far as like industries and PE department is concerned, the role is not there.
Limited.
Role is not there, in fact, Lordship, because
Okay, you be there. Whose role is there?
because cooperative cooperation department is there, because they are the administrative department.
Okay. What are the issues here?
My lord, events of the petitioner before your lordship is that, my lord, the petitioner was an employee of some cooperative government limited, my lord. They have not received their salaries and other benefits since 1996, my lord. In the year 2010, some of the benefits have been given, my lord.
Mm.
But, my lord, the petitioner, after getting that amount, inquired and came to know that he has received the VRS benefit on the basis of pay scale, which was existing at the year in the year 1988, my lord. The Central Wage Board, he has made the structure of the payment, my lord, which was existed for 5 years since 1st of January 1988 till 92, my lord.
Hmm.
Thereafter, no any Central Wage Board has been constituted, my lord. Because of that, the state government have to prepare the pattern of salary for the sugar mills, my lord. But, my lord, in Assam, there are no such specific pay pattern, my lord. But in other states, they have prepared their own pattern, my lord, including UP, my lord. In the year 2010, my lord, in the year 2008, when the employees have not getting their salaries and benefits, my lord, they have approached the Honorable Guwahati High Court by filing a writ petition, my lord. That writ petition was once disposed of on 8th of August 2008, my lord, directing the respondent authorities to decide whether the mill will revive or close, my lord. But same was not done. Accordingly, the petitioner again approached the Honorable High Court to revive the writ petition, my lord. Accordingly allowed, my lord. In the meantime, they have got some of the benefits. After getting the benefit, the petitioner again approached the Honorable High Court by the, my lord, WPC number 4055 of 2000, sorry, madam, 1932 of 2014, madam. The writ petition,
Where is the scheme of VRS?
my lord, I have not annexed, but I have a copy, my lord.
Is it not important?
Important, my lord. My lord, as part of scheme, my lord, tail number 2, it stated in all calculations of DRS benefits, the basic pay and rate of DNS allowance shall be taken as on the date of application by an employee opting for VRS and the date of closure of the SLP, whichever applicable. No request for any revision shall be entertained thereafter.
Hmm.
As such, the petitioner actually entitled to get the salary scale as existing at the time of getting their DRS benefit in the year 2010, my lord. But, my lord, the petitioner praying for
So you want to say you have no objection so far relating to basic pay and rate of DRS as on the date of application of an employee opting for VRS.
Yes.
Now, according to you, on that day, your scale was something different. You have been paid less.
Yes, your lord. Yes.
Now, what is yours then? Who will pay? Suppose we whole it will be paid. Who will pay?
Also, otherwise it has done under liquidation, your lord. The entire organization.
Who took the responsibility to pay the VRS amount?
Lordship,
That is very vital. Where is the decision to go into VRS and who will pay the VRS amount?
My lord, state of Assam, that is, my lord, mentioned in the earlier petition, my lord. It is at page, my lord, at page, my lord, 47, paragraph 8.
According to you, what should be your amount
My lord,
and what is being paid to you?
yes, my lord. My lord, I have annexed an order, my lord, where it has been reflected at page, my lord, 59. That is the impugned order, my lord. The petitioner has
Just
part
a
of
minute, just a minute.
Your lordship, on speaking order was,
yes, my lord,
that was
order date 22/9.
This is by you. This is a claim by whom?
Claimed by me and rejected by this order, my lord. That's my claim. My claim was for 24,86,298 rupees and paid 15 lakhs.
Just let us understand this.
Yes.
How can we decide these issues?
My lord,
Now we'll have to decide everything, fact finding. Can we decide all this?
my lord, I am praying only that, my lord, which
A
state-
liquidator under an order of apparently an certain account then has decided that this should be VRS amount of VRS benefit you are entitled.
Yes.
Admittedly, you have received it.
Yes.
No doubt up to that. Had
Yes.
it been a case that this is the determination made by the liquidator and the accountant, CA, but not paid, this would have been an admitted position we could have directed. Now you say that no, the CA has committed wrong. Now we must be super CA. We will have to see the everything. And
No,
this
my
is a
lord.
matter of evidence.
No, my lord, my claim is not that, my lord. My claim is that regarding scale which will be applicable for me, madam, because under which the calculation has been made by the CA was
Wrong.
existing prior to
Wrong.
48.
Wrong.
Yes.
Isn't it? So
That is-
we'll have to determine all this not possible.
My lord-
Go to civil court, get a declaration that these are the evidence, this is the exhibit, how my salary was issued, these are the VRS. This is not the case.
My lord, regarding calculation part, it is correct, my lord. Only thing, my lord, the CA has calculated, considered the scale as
He has committed mistake.
no, my lord. Committed by the department, my lord. Department, as per department, CA has calculated. I am not.
No,
on
no,
calculation, my lord.
it is been done by a liquidator. What
Yes,
is the
ma'am.
provision to when a person is aggrieved by a liquidator's decision? CA may calculate, but it is the liquidator who has distributed. So if a liquidator's decision, you are aggrieved by a liquidator's decision, can a read court decide whether it's correct or not?
My lord,
Enlighten us.
my lord, that is correct, my lord. But
If
my
that
lord,
is correct, they are dismissing
my lord,
this.
no, my lord, my humble submission is that, my lord, kindly have a look at the order which have earlier passed. This is the repetition continuing to that the earlier repetition, my lord. My lord, in this repetition, my lord,
What is the date of the order, earlier order?
My lord. That is, my lord. Order
That can be
dated-
very good ground for saying that this is a mistake. But with court, I have serious difficulty.
My lord, my humble commitment is that, my lord, I am before your lordship to direct the authority to consider the scale as per scheme, my lord. As per the scheme.
Who will
scale prevail.
consider your skill as on date?
My lord, as per the scheme, my lord, as on.
Who will, to whom I will pass a direction? They will come and say, these orders we cannot implement. I am not the authority.
My
Who
lord,
will pass this order? Okay, tell us, who will pass this order? Who will reconsider your case? Once a
Definitely
liquidator
liquidator.
closes a liquidation process, a company has gone into, or cooperative society has gone into the liquidation, to whom should I direct?
in that case, my lord, direct it to the liquid. My lord.
Then liquidator is no more, Fungus official is gone.
My lord, I'm showing your lordship attention to the order because, my lord, the order stated the state government had come forward to pay the DRS dues of the employees. It was
Understand,
also-
state government has said, okay, this is the corpus, will pay in terms of liquidator and CSO. They have given the money. Liquidator has passed an order that this man is entitled for this, not only some, there must be some debtor, sundry debtors, other parties, secured loan, unsecured loan, employees thing,
Yes,
everything is there.
everything.
And what do you mean by they can even sell out the property in liquidation? Isn't it? Liquidation means it is now liquid, not in solid state. Now, from where you will take out this liquid and make it solid and pass a direction to break the solid thing and give you something more. You show us the authority of law, power of a writ court, we'll pass an order. We cannot pass an order in this kind of cases on equity, sympathy, or humbleness.
That is correct, your lordship.
If that is correct, we are dismissing. We'll say that nothing
I
survives.
have two full prayer, my lord. In
Yes.
another full, my lord, I am praying for the outside alliance in medical alliance, which was also not
We
considered.
cannot reopen.
My lord, I am praying on the basis of.
That is
Article
why
14.
tell us who, to whom I will pass a direction.
My lord, I
To
have-
whom? Why the government will give you? It's a cooperative society. They have said, they have what's your answer? This is a cooperative society, state controlled cooperative society. This is the amount we have given.
my lord, it is rigid to satisfy your lordship. Kindly allow me some time. I have to. Time I will reflect.
This is a matter of 2017.
Seven, but it was actually 2008. Lord. Not even 10.
When the liquidation was over,
2008.
what is your stand?
Lordship, our stand is that he have been paid as per the calculation made by the chartered accountant and the liquidation, and based on that, the government has paid the money. Now nothing survives, your lordship. And regarding the house rent, as per in our affidavit, we have taken a stand that they have been provided with quarters.
Good things, bad things, everything must come to an end one day. Isn't it? Somebody is still thinking 15 lakhs with 20 years interest, it will be around 45 lakhs. I'll buy houses, I'll buy vehicles.
No, my lord.
Isn't it?
Not only for the petitioner, my lord, but I am.
Let us decide what kind of improvement we will make tomorrow, day after tomorrow.
My lord, my basis of the prayer is only the Article 14 matter. All other PSS getting that basis, my lord.
Article 14 will be applicable when you are equally situated. Can it be a principle that all the employees under all the PSUs are equally stated and therefore there should be a parity of VRS among them? Can it be? That
Yes,
will
my lord.
that will be definitely depend upon in a different circumstances of the a company might have a huge liability that even liquidation cannot give money to them. And there may be a company where there is huge liquidation, huge property, but not non-functioning. In the liquidation after selling, gets a substantial amount, bonus, everything, huge package is given. Salaries were higher. There must be a difference between liquidating IOCL and liquidating Jagiroad paper mill, isn't it? So where is the question of discrimination?
My lord, there is discrimination because my lord, pay pattern for this, all the PSUs are same, my lord. And all are six PSUs, my lord.
All
And
the
close that, my
cases
lord.
are not. Because it was also the sugar board was there. So he's trying to
To bring on that sugar board.
that cannot, that because cooperative department has not adopted that.
And then
My lord, let me.
if there had been that this is because it was a proposal from the union that please give us the board. But that was not finally determined that yes, they are and will be entitled because it's a cooperative society.
Yes, my lord.
Isn't it? Cooperative societies liquidation process itself is different under the Cooperative Societies Act.
My lord,
Isn't it?
my lord, regarding this, company of the cooperative mill of this petitioner, my lord,
We have sympathy
Is
for you,
developing
but
this
sympathy cannot be a guiding force for deciding a writ petition.
my lord, kindly allow me some time, my lord.
When? Monday?
My lord, that is one.
No, it is a matter of 2017. When, Musumi?
Next Friday, my, not this Friday.
Next 16th.
Public.
Though this matter is pending, after arguing at some length and on a pointed query, whether after the liquidation process is over and the amount and the amount paid to the petitioner on the basis of a determination made by chartered accountant and paid by the liquidator, whether this court in exercise of its jurisdiction can determine the claim of the petitioner that he was entitled for more than what he has been given, more particularly in view of uh, in view of the dispute raised by the respondents to such claim, the learned counsel for the petitioner seeks for an adjournment to address this court on the SDG court. Prayer is allowed. List this matter on 16/2/2020.
Obliged.
Okay. Musumi.
Lordship, I have checked that UGC regulation was not applicable at that point of time. Even today also, Lordship, not applicable. Lordship, here in this case, Lordship, there is an act, Lordship, Indian Medicine Central Council Act 1970. Under that, Lordship, there is a regulation. I have just Lordship sharing, Lordship.
Ready?
Lordship.
No, I'm asking you, ready?
Before that, my lord, I like to throw the attention, my lord, of Rule 29 and 30 on last occasion.
No, we have detailed order we have passed.
Yes, my lord.
Our anxiety was that this rule is meant for the allotment of mark by the APSC.
Yeah.
This is a rule for the APSC,
Internal regulation.
internal regulation. Now, there are there may be two situations. One is a selection of a person is controlled and guided by a set of rules prepared for that department. Okay. So therefore, when APSC conducts a selection, the said rule is to be followed. In absence of any rule, how selection will be made? Of course, APSC will be entitled to proceed with their selection. So on that date, since it's a post of lecturer, an argument was advanced that this is the UGC regulation on the basis of which the standard and marking patterns is to be maintained. Okay. And therefore, APSC committed a wrong in selecting a person
Without
following the service regulation or UGC regulation. This was the issue. Now today he comes and says just no, UGC regulation is not applicable till that, not only on that date, till date, okay, till date may be applicable, on that date it was not applicable, rather it is a different rule which was applicable and the selection has been made in conformity of that rule. This is your case?
Yes, sir.
So if that being so, what you say? You want to proceed?
Today I have take some time, my lord.
Okay, we can give you some time. Which are the provisions you want to rely?
Lordship, in that,
You have given a copy?
yes, Lordship. That regulation, Lordship.
Hmm.
The second page, Lordship, it is Indian Medicine Central Council Minimum Standard and Education of Indian
Okay.
Medicine Amendment Regulation 2012. Lordship.
Okay.
Under that, Lordship, I have check marked that particular portion. Qualification.
Okay,
and-
let him also go through it.
Yes, yes.
Let them also go through it
Yes.
so that you can properly assist and we can come into it.
Already essential
just consider.
qualification has been remarked in that regulation,
Mm.
but what is the procedure for selection has not been
Not
dealt
been
with.
regulated.
So the
We have-
government has proposed us, then we have dealt with the as per our internal regulation.
Okay, fine. This court, under its order dated 7/12/2023, after recording the fundamental facts for determination of this writ petition, after recording fundamental facts for determination of this writ petition, posed the question whether the UGC regulations whether the regulations framed under UGC Act 1956 shall be made applicable in the selection process, the selection being made to the post of lecturer in an Ayurvedic college, or whether the APSC could proceed with the selection process on the basis of their own regulation. Full stop. Today, when matter is listed, Mr. P. Datta, learned counsel representing the APSC, has submitted that the post in question the necessary qualification and standard of selection is prescribed. Standard of question so far relating to the post in question is prescribed under under Indian Medicine Central Council within bracket minimum standard of education in Indian medicine bracket close within bracket amendment bracket close regulation 1989 comma formulated in exercise of power under section 36 of the Indian Medicine Central Council Act 1970. Full stop. Mr. P.P. Datta further submits that though standards and minimum qualifications are prescribed in the aforesaid regulation, however, the procedure of selection is not prescribed in the said regulation, and in absence of such prescription, comma, the APSC had opted, has gone ahead with the selection in terms of Rule 29 of the Assam Public Service Commission within bracket procedure and conduct of business bracket close rules 2010. Full stop. At this stage, learned counsel for the petitioner submits that he may be allowed to go through the aforesaid regulation 1989 and address this court on the next date fix. List this matter on 19th.
22nd or 22nd.
22nd not possible. 26th? 26th of February. Not 26th. 26th not possible. 28th of February as part heard.
Director of the bank, my lord, was asked to be personally present. So, my lord, may I pray, my lord, in the meantime, certain developments have taken place, and the government is, my lord, contemplating to take some action, my lord.
Okay.
So, can these matters be taken up on 15th, my lord, so that the
If that be so, we need the, if you are here, because on that day nobody was there.
my lord, in representing the bank, nobody was there.
There. So therefore we have no option but.
No, I am not on that. My lord.
No,
Yes.
even if that, if you are here,
Yes.
you are for a cooperation
I am
department.
representing the
Okay,
registrar, secretary, principal secretary, everybody.
Okay, so we have directed presence of the executive officer of the bank.
Bank. My lord. So, if on
Mr. S.K. Talukdar, learned standing counsel representing respondent numbers.
my lord, your lordship may say,
Who is a standing counsel?
yes, my lord.
Standing counsel submits that similar matters are pending before this court, and one of such contempt petition being
My lord, in fact, that is a writ petition. Your
one,
lordship may say WPC
one of such petition being WPC
404/20, my lord.
404/2020
Yes, my lord.
is fixed on 15th of
15/2, my lord.
15 to
24.
2022
24.
2024.
Right.
Accordingly,
Wherein, my lord, the chief executive director
wherein the chief executive director
of Escort
of
Bank
the Escort Bank was directed to be personally appeared
before this
before this court in view of non-representation.
Yes.
In view of non-representation and non-representation. Can you give that order? Okay,
Yes.
give the date. Okay, we'll silo.
My
it
lord,
is also
order
submit
date is 5/1/24.
5/1/24. It is also submitted by Mr. S.K. Talukdar that the government in cooperation department is taking certain steps for payment of,
Not payment.
not
Manoj, but
work,
certain steps, Manoj.
certain steps
Yes.
for implementation
Yes.
of the order.
And then, Manoj, there is an impasse,
Uh,
Manoj, stalemate. So how to come about that?
okay.
Whether it will go for
Government is
liquidity-
also taking up
Some steps, Manoj.
some steps
Yes.
so as to redress different
Yes,
grievances
yes, correct.
relating to the
Entire issue, my lord. Entire issue.
people taking certain steps to settle
Yes.
the issues
My lord. Relating to the
including
escort bank.
relating to the escort bank, including non-payment of dues to its erstwhile employees.
As well as reinstate. Perhaps the
That
issues
that
are
will
different.
include, that will include and different and implementation of different orders
Right.
passed by this court in different writ petitions. Accordingly, he submits that this matter also be fixed on 15th along with the said writ petition.
That would be more convenient.
MS Zahan Learned Council has also submitted, submits that she will have no objection in listing both the matters together. However, her anxiety is that
Yeah.
petitioners are even after direction for reinstatement, the petitioners are not being reinstated till that full stop. As Mr. Talukdar has submitted that government and is taking up steps in a positive direction. This court is of the view that at this stage, without proceeding further, let this matter be adjourned and be listed on 15th of
February.
February, along with WPC number so and so. Only registry to list this name, showing name of Mr. S.K. Talukdar in the cause list.
Yes, yes.
We have passed a
I
common
think
order.
I hope something is done because it's since long.
Is here, because see, this is an issue, we can pass many orders, but ultimately we need a compliance.
Yes.
This is how they are, because I have seen there are certain, in the writ petition, government is ready, that will revive. But revival should result in a beneficial, government is definitely concerned, which should result in a beneficial conclusion.
Exactly.
If these monies are being spent and these officers eats up, how the government will finance? So it's a larger issue. It's not that somebody is asked to be reinstated
Mm.
in a regular department, not being reinstated. It's not like that. Where will you be reinstated?
In a bank.
Even
it
if
is
they will
not-
say, okay, send us to jail for 6 months. Good enough.
And there is the issue of fund also.
Fund also,
And if
because in that writ petition,
Yes.
those are the funds. That's why government took a stand
Yes.
that time and again we are asking to give exact proposal,
Yes.
feasibility, whether we can revive it.
My lord, correct.
And there is a committee, but the bank is not sending. That's why we ask for a personal appearance.
Correct.
Not only sending, bank is not being represented by any lawyer.
Right.
So we have no way out.
That will be more.
I recall now.
Yes,
I think
yes,
I
correct.
passed this, passed that.
Correct, yes.
Remember.
On 15, my
I'm
lord,
not
everything
aware
will
of those
surface.
cases.
Okay, problem. Problem.
Dot. Obliged.
Yes, Upamanyu.
Lordship, here there was a direction
Ah.
to consider the case of the
Ah.
petitioner. Because Lordship, the private respondent has filed an affidavit in opposition stating that he has got some other job. So
No, we understand. That is not the issue.
That-
We have dictated everything.
then Lordship will pass a speaking order as well.
You have passed the speaking order. We want to know from your mouth that this is passed by
The Director of Medical Education.
Director of Medical Education. That's all.
Yes.
কোনে লৈছিল এইটো dictation? Okay, report লাগিব. Mr. Upamanyu has submitted and produced speaking order. They already have directed.
59 is the contempt matter and 60 is the writ
It will
petition.
be Upamanyu.
And for item 60 is the writ petition wherein they have challenged the speaking order asked by the director.
But that has been disposed of.
Yes, Lord. Lordship, the writ
Further, the hospital just to readvise so and so. What happened there? Okay, various varieties, so and so, so and so. At the earliest, Mr. Upamanyu, learned counsel representing the respondents have submitted that the and speaking order. They have filed any affidavit?
No.
And a speaking order has already been passed by the Director Medical Education Assam on 28/7/2023. In compliance of this court's order dated 12/10/2020, passed in WPC 10636/2020. Full stop. The aforesaid communication dated 28/7/2023 reflects that after verification of the documents of the two selected candidates, it was found that those two selected candidates did not have the requisite qualification, training in terms of the advertisement. Full stop. Accordingly, it was concluded that offering an appointment to any candidate who does not possess the minimum qualification would amount to violation of condition of advertisement itself. Accordingly, the Director of Medical Education Assam cancelled the selection process of MRO, selection process of the post of MRO at FAAMC, and the director further requested the college and hospital authority to re-advertise for the post of MRO at the earliest. Full stop. That being the position in the considered opinion of this court, the order dated 12/10/2020 passed in WPC 103C/2020 has duly been complied with. Accordingly, the contempt petition stands closed. The speaking order dated 28/7/2023 is kept on record and marked as document X. Full stop. It is needless to say that if the petitioner is aggrieved by the aforesaid speaking order, he shall always be liberty to approach the appropriate forum.
They have filed a writ petition, that is item number 60, wherein they have challenged the
Contempt petition is closed. Full stop.
Item 60 is-
Opponent closed. And Taragote দিব. The Taragote close or agote. It is in the meantime, the speaking order dated
28/7/2020
has already been challenged in WPC 4828 of 2023. Full stop. The WPC 48 full stop. In view of the aforesaid, contempt petition stands closed. In WPC 4828.
Here we need some time.
Okay. None appears for the petitioner on call. Mr. D. Upamanyu, learned counsel for the health department, prays for and is granted 3 weeks time to file affidavit in opposition. List accordingly.
Highly approved.
Mhm.
I don't think it's a proper case. No, here, please.
Huh?
I don't think it's a proper case.
Covered
Proper case. Well, proper case, he has submitted here that judgment in this case 77.
Where is that covered case? WPC
55/6.
Uma Shankar Nagasati. How can it be said to be a covered case? Same issue,
Same
wearing wrong
wrong page,
rank base.
wrong.
What is the date of the order?
28/12/2000, that is annexed
Tell us.
And-
Order dated
28/12/2002, and 79.
28 12
2008.
2010. Who passed this order?
Mala page 79/85, that is,
Tell us.
yes, madam.
If I need to go to the
Yes,
page,
yes.
I will not ask you.
Yes, madam.
It will take 2 minutes to me to find it out.
Sorry, madam.
We have full
Under
faith on
Secretary to the
lawyers.
Government of India.
Huh?
Under Secretary to the Government of India.
Under Secretary Government of India.
Yes.
And imposing minor penalty of censure.
No, here not madam imposing any penalty, but it is. Yes,
Then
madam.
how can it be
Yes, ma'am.
similar? Why
No,
similar?
Similar method.
Why similar? Tell us. Wait, we'll take up this matter after list is over, you get prepared. We'll decide this. Gayan, go through. If there is an order where how it
Yes,
is similar.
This was the last order dated 29 and 23. Some instruction, petitioner wanted some instruction.
No, I understand. He will not have the instruction. Here, see, Mr. Bora, it's a simple thing. This matter should not be kept pending. Don't repeat the things you have already said. Take your seat. If you want to add something substantial, substantive, or on merit, or if you want to say that your senior is not well, that we know at 10:15. Isn't it? So take your seat. Are you having a competition?
Okay.
Kindly come to page 28. Paragraph 4.
What?
Unnecessary dockets are pulled. Okay, let's go through it. A determination was made so far retrenchment and all in the earlier report. They also come that okay, give us also relief. Court says no, nothing doing, no determination whether your retrenchment can be whether GMC is an authority, industrial unit or not. These are kept open, will not go. However, the ultimate direction is to make an inquiry for determination of the question as to whether the petitioners were engaged by them in 1999 under Clean Guwahati scheme and were subsequently retrenched from service or not. Okay. After such inquiry, petitioners are found to have been engaged by them in the 1999 under Clean Guwahati scheme and were subsequently retrenched from service. The respondent authorities will consider feasibility or otherwise of engagement. There is no direction. If first thing is whether they were under Clean Guwahati. First condition. Second, whether they were retrenched. If retrenched, then you can consider if they can be accommodated somewhere. This is the case, and this order was passed on 2013. We are in 2023, and nothing is proposed. So you have instruction at 2.
No, no, there is a report itself. No, that I have.
Okay, give it. We'll close it.
There's a part of the report has been taken in the record matter. And report is it. Last order.
Closing it. This is 531, isn't it?
531.
The present application is filed alleging willful and deliberate violation of this court's order dated 29/11/2013. The direction which alleged to have been not complied with is quoted here in below. Page 28, paragraph 5. Okay. Mr. S. Bora, Learned Counsel, representing the Guwahati Municipal Corporation, has submitted that in view of such order and in terms of an order passed in WPC, in terms of this court's order, an inquiry was initiated directing all concerned divisional heads, GMC, to submit record of engagement of the daily wage earners under clean, within inverted comma, Clean Guwahati scheme by communication dated 9/5/2023, issued by the Municipal Secretary, GMC. Full stop. Which is, which is also produced before this court. A report was submitted, and the said report, according to Mr. S. Bora, in terms of this said report reveals that except the petitioner number 15, Srimati Sabina Baro, none of the petitioners were except comma, there is no record of engagement of the other petitioners under the Clean Guwahati scheme or any other scheme under the any other scheme in Guwahati Municipal Corporation in any division. It is also submitted that in the said report that the Clean Guwahati scheme was adopted in the year 1994 and same was dissolved long back. However, a meeting was held on 15/7/2023 under the chairmanship of the Secretary to the Government of Assam, Department of Housing and Urban Affairs, to discuss various issues relating to Harijan and Mazdoor Union. In the said meeting, it was discussed and deliberated how to explore the possibility to engage the incumbents whose name appeared in the list. Thereafter, another meeting was held. Thereafter, another discussion was taken in the mayor in council meeting held on 8/20/2023. And a direction was issued to all the executive engineers GMC to necessary action as per the decision of this court passed in WPC 6944/2013. Full stop. As it, from the aforesaid report, it is seen that most of the petitioners were never engaged in the year 1999 under the Clean Guwahati scheme, and those persons who were engaged, their continuation are being explored by the GMC authority. Therefore, this court is of the view that Mr. Bora, the GMC authority shall file an affidavit incorporating the aforesaid fact by way of an affidavit, so that
That's another difficulty.
why
That here the sole respondent is Mona Lisa Goswami. He retired long back. That's the another difficulty. Both the petitioner are not there in court.
they are not interested, they are not having any relation with the client. Full stop. Comma. Therefore, this court finds that no contempt has been committed in the backdrop of aforesaid exercise. Full stop. Aforesaid exercise. The order dated 29/2023 also reflects that Mr. A. Dasgupta, learned senior counsel, made a submission before this court that he requires some instruction from his client. However, his junior, Mr. J.K. Sharma, has submitted today that they have not received any instruction from their client. Full stop. The fact also remains that the respondent contemner has long been retired, and no endeavor has been made to either to intimate the present incumbent who are responsible for implementation of this order or to implead them as party respondents. In that view of the matter, and in view of the report produced by Mr. Bora, learned standing counsel, this court finds that as the respondents are taking steps for implementation of this order, this contempt petition needs to be closed at this stage. Accordingly, same stands closed. However, the petitioners will be at liberty, if so advised, to re-agitate their grievances by filing re-agitate grievances and reopen this contempt case by filing interlocutory application if cause of action survives. A copy of the report on contempt case number 531/2014 is kept on record and marked as document X. A copy of the same also be handed over to the learned counsel for the petitioner. You take it.
I'll participate in handling it.
We'll do it.
Sure.
Get it done, give it to him, and 2 copies.
One copy to me, I will keep it my left. And one.
Okay, this original you give it to us.
Right.
And then you get you to get 2 Xerox copies, give it one to him and one to him, keep one for you. Okay. Contempt petition.
Problem.
This is also, huh? This is also part of mine. এখানে যাব, হ্যাঁ, একটু বেশি।
we have not been able to establish the proper communication with the petitioner since a long time, and without the instructions, we are unable to take any further steps in this case. It is a request before this court to kindly grant us some time so that we can establish some communication with the petitioner and take necessary instructions.
Paragraph 6 of the writ petition rejected on the count of non-able.
Yes,
Page 6, paragraph 6.
page 6, paragraph 6,
Six, there is statement of it.
page 10.
Page 6 of the writ petition. Page 19, Lord Speaker, find the remarks of the Lord Speaker.
Yes,
At least grant us time to take instructions. Or date may be given.
Fair to learned counsel for the petition. The trust and sanction can be listed. Learned counsel for the petitioner submits that they are having no context with their clients. Accordingly, praise that he may be granted some time to complete his instruction in this regard. There is a law, please have the point.
All right.
Order শুরু হয়ে গেল না? Daily hearing. Item
Motion.
you have earlier, they appeared 7 years, whether you have granted or not.
And they have challenged an advertisement, my lord. That is annexure C, page 23 of the writ petition, my lord. My lord, if you go by the rule, it is 90-10.
Okay.
This is direct recruitment.
Okay.
So we cannot manage. That is what we have.
None
in our-
appears for the petitioner on call. Though Mr. R. Dhar, learned government advocate is present. None did represent the petitioner when the matter was called on 6/10/2023. So though the state was duly represented by the learned government advocate. Full stop. In view of the opposite, matter stands dismissed for non-prosecution. Yes.
Yeah, President.
Mhm.
But the matter relates to removal of the petitioner, Sarkari council, from the post of Sarkari council.
Why have you been removed?
But if there was a complaint
Mm.
against the petitioner,
Mm.
Lordship may kindly come to Soko's notice at page 13.
Yes.
13,
1-3.
1-3. The petitioner was directed to submit an explanation against the complaint. Although it is mentioned that the copy of complaint was enclosed, but no copy of complaint was furnished to the
Okay, where is your reply?
reply. I have given a short reply at page 14 of
Yes.
14, wherein I have stated that I could not get sufficient time to prepare the Soko's reply.
Just a minute, let us
Yes.
read this.
Yes.
Then,
Lordship, at page 15, Lordship, I have stated that the reply of the Sokos is to be furnished shortly, Lordship. Thereafter,
okay, then.
Lordship, by order dated 5/1/2018 at page 18, Lordship, I was removed from the post of Sarkari council. And in my place, Lordship, Dinesh Singh was appointed.
Who is representing Dinesh Singh? How can Dinesh Singh be appointed like this?
Because, Lordship, in the state of Assam, Lordship, the Sarkari Gabura holds a civil post, Lordship. And is protected under Article 311(2) of the Constitution.
Where is the affidavit?
The respondent number 1 has submitted their affidavit.
Okay, we'll decide at 2. We'll decide this matter at 2. Have those judgments.
Yes,
It's a
I have.
civil, if the civil post. And what are the procedure? What is the power of suspension? How
Yes.
it can be removed?
Yes. Obliged.
Power of appeal is there, matter provision for appeal.
I've seen that your statement.
Lordship, that doesn't apply in the case.
Alternative remedy is not applicable when there is a violation of principles of natural justice or a statutory right.
Right.
Take that judgment.
Yes, I have.
What is that?
That is, Lordship, 1974 ALR 163. State of Assam.
No, that is not, thereafter,
There is another order of this honorable court in a similar case, Lordship. That was
and there
relied
is a judgment by Honorable Apex Court where it has said that see, this is a civil post, so there must be some terms and condition of service And therefore, we expect that state of Assam will formulate regulation, executive instruction for this service. And accordingly, the age of 65 was incorporated in view of the judgment. Amendment was made to the executive instruction.
That judgment I have not ever.
You are not aware. আমি যেটা গাঁওপুরার judgment দিছিল 65 for retirement. Everything is recorded in that. It will look approved. And LIC, alternative remedy. Yes, madam, what is this?
This is specific to matter, promotion to supervisor matter from
Supervisor.
Anganwadi worker matter.
Promotion.
Yes. From Anganwadi worker matter.
Okay.
So when a petitioner, she has been working since 1996 matter. In Katyatoli ICDS project matter. Okay. And as Anganwadi worker matter. And she's also qualified matter and she has got some extra qualification of by way of she has got certificates. I have annexed that. And minus as per minus at pace minor
What is the selection? What is the reason of
that is the
refusal?
that is the main problem. Madam. There is no reason for refusal and
Where is the affidavit?
Yeah, file.
affidavit has been filed by that.
Any reason
Last
for?
occasion, my lord, on 9/10/2023,
Hmm.
we are directed to, my lord, obtain inspection and produce the record.
Record will be necessary. What
Yeah,
is your
yes,
both
yes, I
reason?
have got it, my lord. And showing how the marks in the Viva was have been distributed in respect of SC candidate.
Hmm.
I have received it.
You
I
have received?
it. Yes. Petitioner, my lord, he is not to the tune of, my lord, selection.
There is no dispute that he is having the required qualification.
That true.
There is no dispute
No.
that she was called for the interview.
Yes.
Yes.
madam.
There is no dispute that she is senior to the other,
Yes.
but her grievance is that she ought to have been
Selected.
appointed being the senior.
Not only that matter, as per the notification matter,
Hmm.
see that marks for oral test matter, that had not been added to mark.
Okay, we'll see the selection.
That is the main thing, matter. And that is also not denied by them in their affidavit.
No, my lord.
We'll see the record.
Is a mark sheet, my lord. How the SC candidates are given marks, other SC candidates.
Which one is the consolidated?
Three boards were there, my lord. Three boards awarded mark.
Hmm.
Board 1, board 2,
Board
3.
1, board marks 2, and board marks 3.
Three.
This is consolidated, comparative statement.
Yes,
Compare-
comparative statement.
Okay.
And final list also with the in our affidavit.
What is the name of this petitioner?
Anu Das.
Das matter.
Anu?
Anu Das.
Anu Das.
In comparative statement, minus she was placed at 891 serial
891.
and at page 12 of their affidavit.
We have annexed already those documents.
Yes, we have it. But
Yes.
fairly-
Page 12. the
These are
affidavit.
marks how it is marks were distributed. That is the malot mark sheet.
This is comparative matter.
Yes.
Page 12. 891 is the serial.
Anu Das.
Yes.
Anu
sir.
Das.
From Nagaon district, SC candidate.
Mm.
And minor written, she got 41.
Mm.
Oral minor only 866 months, 8.66. And total is,
And who was selected?
others are all selected, madam. Almost 284 candidates have been
No,
selected.
no, this is against vacancy. How many vacancies?
Minus all vacancies minus
It's not specific to a center.
Specific sir, for one.
Is it
no, no, madam.
specific to a center or an as a whole?
Different.
different districts,
So they can be posted in any center.
any
Yeah.
center.
Any center.
Now also posts are available, my.
In different.
Now, what is your ranking? This is on merit 891.
Yes, my lord. According to them, whereas my lord, the notification says something else. They have also, my lord, they have in affidavit also it is annexed, and I have also annexed as annexer, my lord, 13 at page 33 in my petition. And they have annexed at 7, my lord.
What
The
is your
affidavit.
case then?
My lord.
What is your case?
My case is that as per notification, that is 4th of June 2012 at page 7 of the affidavit.
Page 7 of the
Yes.
affidavit.
Yes. And before that, my lord, the proposal was made by the director, my
Mm.
to the government of Assam, my lord, Commissioner Secretary, regarding my lord, this appointment or promotion to supervisor from Anganwadi, my lord. That has been annexed at annexer 10, my lord, at page 28 of my report. Page 28. As per the proposal, my lord, it is clearly written, my lord.
Yes.
This is my lord, submission of proposal regarding appointment of appointment in the post of supervisors against 25% reserve quota from among the in-service Anganwadi workers under this directive.
Mm.
Here, my lord, in the middle, my lord, there's a committee made, my lord. There are two committees, state level committee and district level committee, my lord, have been made for written test. Written test is not, my lord, mentioned in the notification, my lord.
But
That-
whether written is held.
Yes, it was held, my lord, as per the proposal.
Fine.
Yes, ma'am. I have no, no, my lord, objection against written test, my lord. So in the middle, my lord, this committee will conduct a written test as per guidelines, my lord.
Mm.
And this guideline is the notification, my lord. that is
At page
posted-
7.
Yes, ma'am.
Yes.
4th June 2012, my lord.
Mm.
So, and lay down procedure and prepare a list of eligible candidates and send it to the Director of Social Welfare, Assam, for final selection of the candidate for appointment in the post of supervisor against 25% reserve quota from among the in-service Anganwadi workers under this directive. My lord, this is the proposal, ma'am. Now, my lord, they have mentioned that in the guideline, in the proposal itself, the guideline is mentioned, ma'am.
Mm.
So guideline has to be, my lord, followed, my lord. And in the guideline, my lord, it is very, very clear, my lord,
Mm.
that in partial modification of the earlier notification.
Which conditions, norms and guidelines are violated according to you?
This is 8, my lord.
8.
Sorry, B, sorry, I'm so
B.
sorry. B, norms and guidelines regarding selection process.
Mm.
Here, my lord, the selection shall be made on the basis of oral interview of 100 marks, my lord.
Mm.
So there should not have been any written test, my lord. So this notification, my lord, they have mentioned in the affidavit.
No. You are mistaken.
What?
That oral interview 100 marks is for educational qualification as follows.
Yes,
You
my lord.
cannot read in isolation.
No, my lord.
60 marks for educational
Yes, my lord.
qualification.
If that is
So
added,
that
my lord.
65 marks is for candidates HSLC, HMLC,
Yes,
first division.
I fall,
50 plus 5.
yes, my
Okay.
my lord, I
Then
can
for
fall under
candidates
that, my lord.
HSLC 40 plus 43.
Yes, my
The candidates Sensor 35 plus 30. So how much is the number now?
37, my lord.
Huh?
I am on a C, my lord. I
Huh.
see. So 37, if it is added with the written test, my lord, then 41 plus 37, my lord.
Mm.
That, and not only that, my lord, the second one, my lord, second clause for length of service, my lord. This is
No, we'll come
important.
one by one. We'll come
Yes,
by,
ma'am.
come by one.
Yes, my lord. 41 is my written test, my lord. Then
Mm.
37 is my, this is if it is considered, my lord, it has to be considered. This is mandatory, my lord. This process. 37, my lord, then I get 78, 8%. And after that, my lord, length of my service is more than 20 years, my lord. I'm 22, my lord. And now, my lord, I am 26, my lord. length of service, I get only 10 marks. So 10 marks,
How they have answered to this?
they have not said anything in the affidavit, only said cutoff mark is 50.33. Whereas in the proposal, there is no cutoff mark mentioned. ma'am. Minus at page minus in their affidavit, ma'am. 5 minus.
Mr.
Para 5.
Yeah,
My lord.
you have given an comparative marks obtained, member 1, member 2, member 3.
Yes.
Okay.
Yes.
Suppose HSLC. HSLC is determined. Suppose you pass HSLC
First division,
in first division, 55.
Hmm.
Okay.
second division,
Second division is, why this plus 3 marks?
which one, madam?
Come to page 7 of your affidavit.
Yes. Notification.
For educational qualification, 60 marks. Okay.
To 10.
For candidates pass HSLC, HMLC in first division, 50 plus 5.
Five
5 for what purpose?
First division.
First division is either 55 or 60. Total 55 marks. Why 55 marks?
It is not understood.
This is one.
However, my lord,
Now we come to your comparative statement.
comparative
Suppose
statement-
suppose a person passes first division.
Hmm.
He will get 55 marks. He or she will get 55 marks as per your notification. That 55 marks should be given by all the persons, that cannot be different. Now, for Kusum Soikia, serial number 1, educational qualification, HSLC, member 1 5, marks obtained, member 2 6, member 3 9, total marks obtained 20. Whether this is interview mark or what, or marks again HSLC.
No, no, but it is marks is given, my lord.
Edit my,
My lord,
edited that.
this
Guideline is not followed, ma'am.
Now, who are these selected persons? All are party.
Lots of quality.
I cannot make parties, my lord. So many, my lord, 284.
Now, how will this, if this is, suppose we set aside this selection, it's a common selection.
Yes.
Now, what will happen to
They
those?
should
Selected
follow
candidate
the
has to be-
guidelines, my lord, as per guidelines, ma'am.
But this is lots of quality.
When the selection was taken?
2016.
16.
But your this guideline you have relied on the basis of which these marks, according to you, are given, was notified in the year 2023.
Lots of quality, it is this one, my lord. Notification 2006. Our
No-
instruction, my lord.
Huh.
This as per notification 2006. 2012 is a partial modification.
To understand.
Yes.
Partial
2006,
modification of earlier
2000
notification so-and-so in superstition of so-and-so, the governor has is pleased to notify the norms and guidelines for selection of candidates for appointment of promotion to the post of supervisor against 25% reserve
Yes.
quota from among the in-service Anganwadi workers, which are as follows.
Yes.
Isn't it?
Yes.
So this is the part. Now, so far relating to guidelines, that selection shall be made on the basis of interview of 100 marks distributed as follows.
As per 12.
So
2000
100 marks interview, suppose a person passes HSLC in first division. What the interviewer will do? He will ask, okay, will verify 100, you have got 60% in matriculations, you are first division. You are 55. Where is the question of interview?
My lord, lots of quality, this is instruction. 2006 notification. Norm. 1.
Hmm.
As per government notification dated 12/12/2006, selection shall be made on the basis of written test in general English, SSC standards, arithmetic, general English, so and 75 marks, and oral interview for the 25.
Hmm.
2006 notification.
Hmm.
Reason given, general
Hmm.
English, 75 marks, and distribution of marks on oral interview 5, 10, knowledge function 10, presentation of question answer 5, award of recognition award, Wangabadi award of 5. These are the 2006 notification.
Hmm.
Now they are saying 2012 notification, some modification has been given.
Hmm.
The 100 marks oral your oral interview. But so far written test is there, my lord.
Okay, written test is
It
there,
is
okay, we have,
75 and
we have,
25.
we have no quarrel on that. Now suppose written test is there,
Yes,
she has passed the written test. We are not on written test.
yes.
Now question comes, if this is the selection process,
No, my lord, if she admitted and she accepted,
Hmm.
written test is accepted,
Hmm.
then she will have to accept the notification 2006. Because the notification say,
no.
no, but this 75 marks is for written test. What you kindly say?
Hmm.
She has accepted the written test, 75% out of 75%.
It's not question of C, it's a question of sanctity of the selection process.
Yes, that is, my lord.
This is not question of C, but while sanctity of the selection process, we'll have to see at the same time. And here the other parties, we cannot pick and
Yes.
choose and set aside whose
all-
appointments we will set aside.
Yes, there is no made party.
Whose appointment we will set aside.
My lord,
Successful
that
candidates are not
I
made
am
party.
not on the appointments, my lord. I am only, my grievance is against me not selected.
So you
Because-
have not been selected
Yes.
by not adhering to procedure formulated by the department itself.
Yes.
So if we go by the record, prima facie view is that application has, that procedure has not been applied to any case.
Yes.
If not any case, then whole selection will fall. Can we direct that this whole selection will fall in absence of these 800 candidates?
Cannot be.
My lord, the entire process is wrong, my.
He is not challenged.
That
my
is
lord.
what we are
Entire
saying.
process is wrong.
Entire process is wrong. Fine, accepted, dictate this order.
How
This
can
entire process is wrong.
they be allowed to continue, my lord? If it
They
it is
cannot be
all
allowed to,
wrong,
they
yes.
cannot be allowed to
I
continue.
will be also deprived, my lord. In
They
that
cannot
case.
be allowed to continue, but
I will
enlighten
not
us.
be benefited, my lord, by.
No, it's not a public interest litigation.
Yes, my.
It is at your behest. Suppose a whole selection goes, what will the effective order?
My lord, this election next, my lord, appointment, my lord. This guideline has to be, my lord. followed.
Oh, that is the third phase. Second phase is set aside the selection of all these 800 persons.
You
Yes,
are
my-
making the parties.
Is that it?
Yes, my
Take a seat. Can we pass that order
lord.
in absence of them?
My lord, they could not be, my lord.
No, they could not be or
Yes,
should
my lord,
not be, is
284,
a
my lord.
against third question. The specific question is whether in absence of this selected candidate, we can set aside this selection process being vitiated by procedure established under law.
That is good.
Not crucial, it's clear. It cannot be.
Yes.
So this writ petition is liable to be dismissed for non-tender of necessary parties.
My lord, if I'll, my lord, challenge to select this much. That I have done,
You have done it.
not individually. I have not made them parties individually. Only 3 of them were made parties. Only 3 of them. That too ST, my lord. I belong to ST. So ST candidates were.
Your ground is a general ground, not only SC.
My lord, in case, my lord, if the selection process is not, my lord, proper, and I have not given that opportunity also, my, yeah, and also not added my marks, my, then obviously, my lord, my personal gift. So I've been deprived anyway, my lord, if the select list also, my lord, cancelled.
You are deprived, but we cannot withdraw a benefit or a right to a person
Then in that,
without hearing them.
my lord, without hearing them means, my lord, what they would say, my lord, they will say we are selected, my lord. But
We
thing
want
is
to,
that the
we want,
government
we
authority,
want
my lord.
propose to say that you will decide that they have nothing to say.
No, my lord, what I'm saying, because they are in a better position, my lord. They have selected, they are appointed, they are working, my lord.
That's why we cannot interfere with their
They-
selection
you
process.
just understand, my. But selection, that selection procedure, and also the select list, the final list, that I can, my lord, modify. In this.
You can modify mean
modify means amendment. I can amend the petition.
You can do whatever you like, but problem is that this matter
Challenging-
is pending
challenging the
since
Final list.
pending since 2018, and the selected persons are not before us.
Only 3 of them, my lord, SC category, 3 of them.
SC is there, but your whole ground of selection is violation of a regulation. If still SC goes, general will also go.
So can I get some? time
See, we have
to
already
challenge
spent.
the final list? Otherwise, my lord,
Hard.
18.
The Chaudhary, learned counsel for the petitioner, also Mr. T.C. Sutia, learned counsel for the respondent. Mr. Sutia has produced the selection record
Pursuant to order, my lord.
Pursuant to this court's order dated
9/10/2023.
9/10/2023. First of all, the basic grievance of the petitioner is that her candidature to the post of Anganwadi
Supervisor.
supervisor,
Supervisor.
her promotion to the post of Anganwadi supervisor from the post of Anganwadi worker has been, her claim has been negated in total disregard of the procedure laid down for such selection in terms of the notification dated
12/12/2000.
No, no.
No,
4th
12.
June 2012.
notification dated
4th June.
Huh?
4th June.
Notification dated 4/6/2012. She submits that mark has not been granted in terms of clause B within bracket 1 within bracket Roman 1 and Roman 1-C. Full stop. Not only that, the 10 marks which she is entitled against her experience, as prescribed under clause B within bracket small clause capital B within bracket small a within bracket Roman 1 within bracket C of the notification dated 4th of June 2012. Full stop. If in the event this court accepts such contention of the petitioner, this court is to interfere with the selection process. A common selection process was initiated for selection of posts. Selection of how many posts?
See, I think, my lord, total post is
Huh?
Selection is for 284.
A selection of 280
84.
posts of Anganwadi workers
independent.
under 25% category from 25%
25.
25%
Reserve post.
category of promotional post. In that event, many a person's selection is to be interfered by this court. However, except some SC category candidates, others are not arrayed as party respondents in this case. At this stage, Mr. MD, as Dr. Chaudhary,
Eh.
M. Dr. Chaudhary, MD Chaudhary, learned counsel for the petitioner submits that she may be granted some time to
Do the need.
look into this aspect of this matter and do the needful, if so advised. Prayer is allowed. List this matter. After
First.
list this matter in the first week of March. March 20,
Second week.
second week of
I'm-
March 2024. Mr. Sotia may keep the record. Mr. Sotia, you take this also.
Oh, yes.
Village number 2 Bellberg. On the same date, another order was passed that he was again appointed the Gaupura of 3 villages at page 7. Thereafter, Lordship may kindly come to page 13. This is a Stoker's notice with the direction to submit an explanation against the sustained law. Against the complaint law, Lordship, here the enclosure is photocopy of public complaint petition law. That was not. Thereafter, it requires
How could you reply that these are false statement and this and that?
Lordship, at page 14, Lordship.
Ah,
Stoker's reply, Lordship, he has stated that at page 15, Lordship, the reply of the Stoker's is furnished shortly. It's not the complete fact. It's because the complaint petition was not filed.
no, you say the candidate of SGB. What is candidate of SGB?
SGB means Sarkari Gaon.
Ah.
Gaonpura.
Dinesh Singh
Dinesh Singh,
himself
who is
is
the
a
respondent number
complainer against me. And complainer C. Ibras Podel is not a resident of under Biharwari. Okay, how do you know that this person has filed a complaint? Now go proceed further. Serial number 3, who told me to settle his case about land dispute with his brother, lost at Deputy Court, which is not a power of. Moreover, sir, most of the signatures taken in the complaint are not real. Perhaps the signature collected of the purposes are introduced in his complaint. Proper inquiry may show the real picture.
Lordship may kindly come to the next step.
Ah.
Because that was the subject matter of the general meeting that was held on 12/12/2016. Sir, in the general meeting held at the
That we understand, but the way that you say that you have not received, that has been raised first time in the repetition. In your reply, it is not your case that I have not received the reply notice, therefore I cannot reply. Show us anything on that.
Lordship, I have stated that I have only received the notice.
Where is that?
At paragraph, first page, Lordship, page 14, Lordship, first paragraph. I have received the notice on this day. Only notice.
No. Notice means notice along with the annexures until
That
and
was not funny. I have stated in my reply.
have you stated in the so-called reply? You can say many things in here, but you have not raised that issue that I have not received, therefore I am not in a position to reply. Rather, you say that complaint number 1 is so and so, complaint number 2 is so and so, complaint number 3 is so and so. Where, how do you know that?
Because that was the subject matter of the general meeting. That is,
Maybe,
yes,
but
that
then,
is
so
because-
don't argue that. You argue on other important points. This is you cannot argue.
Lordship has stated at page 15, Lordship, that the reply of this proposal is to be furnished shortly. Lordship.
I know that.
That-
That you can argue. I said this was my preliminary reply.
Yes,
I sought
yes,
for
yes.
time, but
Yes.
my response was my reply was not that part was not redressed. Rather, straight away they passed this order.
Yes, Lord.
That can be a ground, but
Yes.
it is not a case that copy was not.
Lordship, thereafter also no article of charges were there. No inquiry was conducted. No personal hearing was given. Lordship, and in their affidavit in opposition, Lordship, they have stated that
Where
at
is,
page
where is
4,
the order?
order is at page 18, Lord. Page 18, Lord. Not Lordship, the affidavit in affidavit in opposition filed by the respondent. At page 4,
Okay, yes, Mr. Chitti. ठीक है sir.
My lord, and annexer is the appointment letter. If you Lordship look into it, my lord, it is appointment in a pure temporary nature,
But that is not the ground for termination.
my lord. Yes.
Hmm.
Permit my lord.
I have seen that.
And they are not getting any regular scale of PMR. My lord, Sorkari Kampura, they are only getting a, my lord, honorarium of rupees 3,000 money. So there is no scale of pay,
Hmm.
nothing regular, the appointment is not of regular nature. This is the first point, my lord. Second, Lordship, whether it is a, my lord, the post offered under the, my lord, appointed in a post, substantive post or not, my lord, whether it comes under Article 311 or not, my lord. Is it? But it is, my lord, that post, my lord, there are two sector of post in the autonomous council area. One is state sector, that is something by the state government, another is council sector. He is not an employee of a state sector. He is appointed by the council under the council sector, my lord, not council. And if your lordship look into the, my lord, provisions of 6th schedule, my lord, there is a provisions of appointment of chief or headman. That accordingly, my lord,
Constitution. Constitution.
paragraph 3, my lord.
Just a minute. No?
Paragraph 3. Power of the district council to make law. 1. The regional council for an autonomous region in respect of all areas within first region, and the district council for an autonomous district in respect of all areas
within the district, except those which are under the authority of regional council, if any, within the district council shall have power to make law with respect to G, the appointment or succession of chiefs or headmen. So that autonomous council have the power to make appointment of the chief, my lord. It is not under the, my lord, Assam Land and Revenue Regulation, that Sarkari Council. It is not like that way. It is autonomous council area. He is appointed a head, my lord, Sarkari head Gampura, and on a honorarium, not on a regular scale of pay. The first. And second point, my lord, here the so-called complaint was received against the petitioner, my lord. We have annexed a complaint in our affidavit of, my lord, and the so-called notice was issued. And that is the record, my lord. Enquiry was, my lord, conducted, my lord. And on the basis of enquiry and the report, his service was terminated. Lord, to peruse the record. And regarding, my lord, alternative remedy, my lord, two judgments are placed, my lord. Lordship, serial number. This is a flag mark, serial 165, my lord.
Just a minute, just a minute. But your stand is something different in the affidavit.
Regarding rule, my lord, that.
You say that
My
you
lord,
got RBI
that is
Land
not a
Revenue Act 1953, and by virtue of that you have adopted
My lord,
Assam
my
Land
lord,
and
I'll submit
Revenue
it.
Regulation.
I'll submit it, my lord. If you, that rule that has been quoted, my lord, rule 160, my lord, that is not a settlement rule. It is the executive instruction of the, my lord, government of Assam, my lord. It is not the rule. We have adopted, my lord, Act, my lord, Assam Land and Revenue Regulation, along with the rule, not the executive instruction. That is my submission.
Where is that?
My lord, my lord,
But you take a stand, then question of alternative remedy, you forget
yes,
it.
alternative remedy is there, my lord.
No question of alternative
My lord.
remedy. You can have either that this is not at all applicable,
My lord.
or it is applicable, alternative remedy is
Yes,
there.
yeah,
Which
my
one?
My lord, Lordship, before that, my lord, Lordship, look into the paragraph 12 of the 63. Paragraph 12 of the 63. Application of Act of Parliament and of the Legislature of the State of Assam to autonomous district or autonomous region in the State of Assam.
Not automatic.
My lord,
Automatic.
not automatic.
Not automatic.
Not automatic. Not
Not
automatic, my lord.
That is clear.
My lord.
But in your affidavit, you have taken a stand
My
that
lord.
this is not automatic. We have enacted an act
Act.
by virtue of which we have adopted Land and Revenue Regulation.
Land and Revenue
And
Regulation.
therefore, the where the words deputy commissioner and so is
Is
used
there.
should be read as so and so, so and so.
Fine.
So in
Mm.
toto, you have accepted Assam Land and Revenue Act
Assam Land and Revenue Regulation with the rule.
with the rules.
Rule.
Okay.
But the appointment of Gaumbira is, it is not under
It
the
is
rule,
an
it
executive
an
instruction, so we have not adopted, we will have
Yes.
our own executive
Mile,
instruction.
mile.
So therefore, if you have not opted for executive instruction, question of appeal, alternative remedy also, you need
Mile,
not argue,
Mile.
isn't it?
Mile.
Either you say we accept it, so
Mile,
therefore
mile,
alternative remedy.
mile.
If not, forget about
Yes,
alternative
mile,
remedy.
mile,
Okay?
mile.
Now, what is your rule holding the service conditions or determination, appointment, termination of Gambura's?
Gaumbira. My lord, it is a honorary post, my lord. It is on.
No, honorary admitted.
My lord, admitted,
So do
my
you
lord.
propose to say that since they are honorary, we can terminate them
No,
as we wish?
no, we can terminate them, my lord, by following the procedure, my lord, in a.
What is that
procedure?
procedure of law?
By following, issuing the so-called notice, after issuance of so-called notice, making an inquiry, and thereafter. his
Put
coming to the-
any executive instruction on
my
your
lord,
own,
on that,
or
my
it's
lord,
a basic fundamental principles of natural justice?
my lord, basic principle of fundamental justice,
Oh, so
That
you
is-
don't have any
my lord.
nature. So therefore, according to you,
Right.
since it is a temporary post, executive instruction is not
Not-
adopted
Right.
by adhering principles of natural justice, we have terminated
Right.
his
That is-
job. That's your case?
That's it.
Which flag you want to see?
Serial number 165. That is the complaint petition, my lord.
165.
Serial. We have already flagged.
Okay, you have annexed already.
And then, my lord, serial 168, the ARO report submitted to the joint secretary.
This is 168 is the report of ARO.
ARO. And on the basis of the report, service of the petition. That is the factor. And the 170 is the so-called notice, and 170 is the reply of the so-called notice.
That you have annexed already.
The reply, so-called reply submitted.
Where is the SOCOS?
So-called that serial 170.
170.
Writing is also there.
Who is representing the private respondent?
Lordship, by order dated 13/9/29. Service was complete, that is why it was deemed
How it was deemed from 19?
13/9/2019 in my brief. Order dated in
Heard. You are Mr. Huh?
I Timothy, sir.
Yes.
I complete the law.
Yes.
Lordship, may kindly come page 4 of the affidavit. At paragraph 6.
Was
Page 4, paragraph. Lordship, in the affidavit in opposition, they have stated that the respondent number 2, on receipt of the report from the field official, put it up before the authority, and upon perusal of the report and on examining all aspects of the matter, the authority of the KAC decided to terminate the service of the city. Lordship, but the court, Lordship, they have not enclosed in this affidavit in opposition. And Lordship, in the order, Lordship, if you order at page 18 of the writ petition, there is no mention of as to the report was.
where we want to give a chance to the respondent number. Notice to be served through the officials of Mr. Sutia and an affidavit is to be signed.
Whether he is presently working or not, my lord, Dinesh Singh, my lord. I don't, if he is working, then I
If
can.
is your thing,
If he is
you give a report,
What?
if then. Heard P. Mojumdar, learned counsel for the party. Petitioner and also heard Mr. Sutia, learned standing counsel for the KAC. By the present writ petition, petitioner assails an order dated
5-1,
order dated
5-1-2008.
5/1/2018. Whereby the service of the petition as Gaubura, what is SGB?
Or Karikam.
As service of the petitioner as Sarkari Gaubura of which
Plus,
of village Belbari number of village Belbari number 2 was terminated, and in his place the respondent number 4 was appointed. The basic ground of challenge is that the service of the petitioner has been terminated without following principles of natural justice, inasmuch as a post of Gaubura is a civil post. It is the further case of the petitioner that a show-cause though a show-cause notice was issued on 25/9/2017, by his reply, the petitioner partially replied to the allegation. However, a request was made by him through his show-cause reply dated 8th of October 2017 to 2017 to file a proper reply. Thereafter, the impugn order dated 5/1/2018 was passed. 2018 passed. Therefore, the basic grievance of the petitioner is that the basic requirement of principles of natural justice has not been followed. Full stop. Countering such argument, Mr. Sutia, learned counsel representing the KASC, has submitted that some villagers has raised lodged certain serious complaints regarding the conduct of the present petitioner as Gaubura, and therefore, on the basis of this complaint, the petitioner was asked to file a reply. Therefore, it cannot be said that principles of natural justice is violated. Mr. Sutia further contends that the post of Gaubura under the council are temporary in nature, and there is no specific procedure laid down for termination of such gaoburas, though the council is adhering to the principles of natural justice by issuing notice and having inquiry in this regard. Referring to the record, Mr. Sutia submits that similarly, as an inquiry was conducted by the Assistant Revenue Officer, Donka Revenue Circle, Dokmoka, and said, is not it? Who page 168?
My lord, on the basis of the state report, this is what was taken.
Come on. Page 168 or something like
168.
Huh?
In my note, it is 168.
this is a proposal for appointment.
ARO report is there. I have parked it on the SCC flag is there.
Okay,
Four flags are there.
okay. Report by Assistant Revenue Officer Dokmoka. Dokmoka, addressed to the Joint Secretary Revenue, Karbi Anglang Autonomous District Council. The record has also been produced by Mr. Sutia, which reflects that the report is a communication whereby a proposal for appointment of Sarkari Gaubura in the village in concern was made on the basis of made in favor of the respondent number 4, who, as per the said report, has been selected by the local villagers. The said report files a mention that said proposal finds a mention that as report was submitted by field staff to the effect that the petitioner has committed some illegal, some antisocial activities since long, and for which the local people of the area are disappointed with him. And on the basis of such report, the service of the petitioner was terminated. It is a specific stand of the petitioner that the inquiry conducted was perfunctory, and no specific findings, not only there is any specific finding in the inquiry report except some vague statement, nor any opportunity was granted to the petitioner to rebut such allegation, inasmuch as even if the petitioner is a temporary employee, as urged by the Learned Standing Council for the KASC, when the inquiry report itself declares that the termination is stigmatic, a proper chance of hearing ought to have been given to this petition. This will go, Mr. But we cannot do it without things. So that's why I've recorded. Again, we will have to exercise all this. We have already wasted
But
time.
we look into the record matter, but they are in the record.
That is the full stop. Full stop. The principles of natural justice mandates that a reasonable opportunity must be given to a person before taking any action which prejudice or affects the right of the said person. It is also well settled that an adjudicating authority must disclose all materials placed before it and must give reasonable opportunity to the affected to submit his/her/their case. A fair hearing means a person against whom an adverse order is passed should be informed of the charges against him by giving him an opportunity to submit his explanation to the charges, and the person is also have a right to know the material on the basis of which the allegation is proposed to be decided. In the case in hand, the basic allegation is complained by some villagers. The inquiry report concludes that there are some allegations. However, there nothing is discernible. What are those specific allegations and how those allegations are established? Above all, from the record, it is clear that the petitioner was not either served any copy of such allegation or any statement of the villagers that has been on the basis of which the termination was made. Therefore, the action of the respondents are suggestive of an action taken in violation of the principles of natural justice. However, this court is not for further proceeding as this stage, as in the event any final determination is made today, the same may lead to termination of the appointment of the respondent number 4. Full stop. The notice upon respondent number 4 has been presumed to be served, and there is no direct evidence on record to show that the aforesaid notice has actually been served upon him. Full stop. Therefore, the principles of natural justice also demands that before this court takes any final conclusion, a notice should be served upon the respondent number 4, as this court has taken a prima facie and tentative view only. And accordingly, it is provided that the petitioner shall as the respondent number 4 is serving as government Gambura in place of the petitioner, let who do? Let respondent number.
Is made a person. Hello, Assistant Revenue Officer.
Therefore, let respondent number 3, that is ARO, serve a copy of the writ petition upon the said respondent and thereafter file an affidavit whether he could serve the notice upon the aforesaid respondent. filed an affidavit before this court whether he could serve the notice upon the aforesaid respondents. Full stop. For facilitating such steps, the learned counsel for the petitioner shall do the needful for issuance of the notice as well as serving the copy and the order of this court upon Mr. Sutia. Full stop. The entire,
He can serve to the AR also, my lord. Yeah. He is a resident of AR, my
no, he will be better. Then he will,
I'll also serve, my lord, but he can also.
he will dispute. He will not accept. Who are you? At least, you, if you ask the ARO, that will let us decide whatsoever. So we'll facilitate the necessary, including including copy of the writ petition and orders, and such steps should be routed to the registry of this court. Full stop. Accordingly, list this matter after 4 weeks on a date, give a date after 4 weeks. Records produced by Mr. Sutia is returned back to him. He may retain this record till the next date. 11-3. Sutia, any difficulty? No. Yes.
Regarding arrears,
Hmm?
meted arrears, they have filed an affidavit. of
Yes.
Yes, sir.
Your smile says that you are ready to pay.
But this moment, my lord, we don't have money.
Huh?
We're supposed to receive a fund from the government. Still, my lord,
Okay. Any supplementary budget? Budget session is going on. Thor?
My lord, during morning only, my lord, there is an issue regarding the cut tax. How long government will go on? That is the thing, government will
So
decide.
they say that they are seeking money, but how then at least in Escort Bank there is a liquidation. Or in case of that Nagaon or something cooperative mill, there is a liquidation, at least these persons are honored. Arpit, what are you having? The 2 shops in Ambari or anything more? Building, land? Yes, let us give a list.
Yes.
Okay, we'll send it for liquidation. So and give the list of the due. We'll take judicial notice and go ask for a liquidation. Fine. We'll say that you have agreed that for liquidation.
for the list of parties.
No, list of property will not, we don't have any happiness looking at your properties and feel jealous. We want your property so that it can be liquidated. If you agree to that, then we'll call for the. How far?
If they have pilot submit proposal, I'm not aware, my lord.
They say that's rupees.
Proposal means what? They will be getting some grant in it.
How far will you give grant in aid?
We have been giving, my lord. That is the problem.
That is that you have created some beggars. If they cannot sustain, go for liquidation. How can these people wait? If you cannot run a business properly, these people are here, others will retire tomorrow. Isn't it? And then you will say we need recruitment. Again, you will appoint somebody. They will not get salary.
21 pending salary here.
Huh?
Regular employees, my lord. There are 21 pending salary. Yeah, 35 of the. Yeah,
Wife of that is. Who is your managing director?
At present, there is no regular managing director. Interim director of this
So managing director is also getting salary from endowment tax side, not from the. What to do? Say us. You cannot force government. No, problem is this. Please this matter before any other bench without me. Parwari, Happy Villa. He has retired. He was a senior official. He died also. I appoint him something in departmental proceeding. That Navagraha Road. See the address?
Rabindranath Kaur.
Huh?
Rabindranath. He is the branch manager of Gwalpara branch.
Oh, no. Only
Gwalpara
the-
branch.
Somewhere I've seen Mukul Deka. Where is that?
That is the affidavit in opposition filed by respondent number 2.
Please this matter before any other bench. Without me. Yes, Mr. Kaur.
First, I have to justify myself as how this person who has died on 29/11/2013
Hmm.
and this immediate financial penury still exists.
Hmm.
But on perusal of the affidavit filed by the state government, it appears that it is not due to the license or fault of the petitioner that his application was delayed. Initially, there was a typographical error.
When
Last line of the affidavit says.
you are here, we'll deal with this matter on a very proper day, properly hearing. Let us not,
I was just
because you'll have to address the recent development,
Yes.
which says even pendency will wipe out the right. What to do?
Because I think that we have to, because the last case was of state of West Bengal versus Devabhatta Tiwari, which says that if the fault can be either of the petitioner or
Or
of the
can be,
government.
but the substance is the immediacy. The word use is immediacy.
Only I will request my friend, if the government of Assam probably has the scheme for appointment of commissioner appointment. I did not appear for long for commissioner appointment.
2017,
I'll take the scheme from the government because ultimately this right has to be traced to the scheme. So let us have a look at the scheme that I'll address your lordship because 2013 and now we are in 2024. That will defeat the very purpose of all the.
Earlier, we used to pass order first round, second round, third round. Now, in Devabhatta Tiwari, the Honorable Apex Court has said that this delay or immediacy may be lost during the pendency of a proceeding.
Yeah.
But the fundamental thing for consideration is the immediacy.
And earlier.
So, but other way, that may also lead to a situation where some favored people's cases will be treated
Yeah.
immediately. Others cases will be kept pending because judgment is their fault we cannot go into. So how to balance this right of people?
And deliberate mistakes may also be done.
We can say very well, okay, this Supreme Court has said we can do this, but there is a larger issue is here.
And there is also one judgment, that earlier judgment of Honorable Justice Ranjan Gogoi, which said that 2 years was the time limit in that judgment. But Devabhatta Tiwari's case, the entire guideline has been framed. And it's very hard on either party or for us because it says that even if the fault.
But law declared by the Supreme Court.
Yes. So
That
we
is
have to.
pending before any court order.
Yes, that is what we are saying.
But a word of caution has also been given that the government officials should be very careful. That's also obvious.
In a way, we are thinking that can there be a direction, even not appointment, for compensation? If the fault is on the government.
Then my lord, just I'm filling in something, my lord. Then my lord, this scheme, my lord, compensation appointment scheme, my lord. One thing is that these petitioners, they are getting a pension. The moment
No, this is not,
That-
the
that-
issue is a
That is,
damages in a public law remedy. We are not determining what should be the compensation.
No.
What are we saying is that this is a thing.
Yes.
Because we cannot give a situation, take into a situation where you can do whatever you like by virtue of a judgment. There must be some responsibility fixed.
Yes.
Suppose you keep unnecessary, one application is given on this date, other is given on that date, you keep the first application pending, you take up the second application from the file, the first loses its immediacy and the second gets,
And
okay, comparison you will have to make. It's not that seniority claim will only be the basis. The basis will be comparative hardship. Two persons, one is having 10 bighas of land, having a shop,
economic consideration.
that is a different, and other is having nothing, that is a different. But question is, suppose by virtue of the above theory, we say that we are hands are washed, we
but your
cannot
lordship-
do. But cannot we say that going into the matter on the record that you have committed, so prima facie on public law remedy, this compensation is fixed with a liberty to the petitioner to have the actual compensation in a civil.
without going into that also, my lord, just like in a wrongful confinement.
Hmm.
A person
that
has
is
to
why-
have that same.
In public law remedy, we'll have to make a determination that a wrong was done.
Then after that, your lordship can also fix the compensation.
That will
Uh,
fix with a further liberty to go
Yes.
to the civil court if you are
Just
still.
like your lordship does in
In
those
that-
wrongful confinement
Confinement.
cases.
This is one,
My lord, then
Don't be-
we'll
don't-
decide on
don't be
file.
so worried. These
Fine.
are the ideas.
Fine.
These are not the final things. Please this matter on. As agreed to with the learned counsel for the party, please this matter on. Possible,
29th of,
February,
so let it be on March,
March.
my lord.
give him a date.
My lord, 11th of March.
Hmm.
Or 12th of March.
12 is better.
11th of March 2024, registry to list this name showing name of Mr. Arthur Learned Counsel.
Deep level.
Hmm.
The matter regarding I have challenged the private exam.
Promotion from what to what?
The post of junior
Hmm.
from grade 4. Lordship kindly see
What is the order of regulation? Grade 4.
page 25. Column C, Nalpari. My name is appear in
What is your department?
diary
Development Department.
Your name is?
serial number 146 Lordship, Arun Chandra Chaudhary.
Where is that? Nalbari.
Yes.
Page 25. Which district?
District Nalpari, page 27 Lordship, last column.
Page
column.
27. District Nalbari. Yes.
My name is appear in 146 Arun Chandra Chaudhary and private respondent is page number 28, 162 Nagen Chandra Tal. Lordship, here kindly see the date of appointment, initial appointment. Petitioner,
What is the criteria for promotion?
this is the question, Lordship. On what basis they have deprived
Where is
me?
the order of promotion?
Page 92, annexure 16.
Page,
5 copy.
page 92.
Nagen Chandra Talukdar, promoted as Lordship.
Promoted as?
Junior assistant under the established.
Yes, what is the criteria?
Lordship,
What is the service rule says?
Lordship, as per regular.
This is a dairy development is under Union of India. State. Under which department?
Animal Husbandry and Veterinary Department.
Okay.
Lordship, the petitioner has regularized against the superannuary post as well as this private sector also. And I'm relying upon the affidavit filed by the department and is not governed by the district establishment ministerial service rule.
Okay, fine. Okay, forget about that. That is not related. But what is your criteria we are asking there?
Lordship,
There are two person. You have promoted. What is the criteria for promotion? Seniority come merit, merit come seniority, examination.
on depending upon the ACR service rule, special report or recompensation.
Where is that DPC committee meeting, DPC meeting?
Lordship, as per, kindly turn to page number 25, annexure 4 of the writ petition, Lordship. In the top, the regularization was on the same date, 22nd of July 2005.
Okay. So if it is the same date, what should be the, if you say that it is a criteria of seniority, if regulation is the same date, what should be the criteria? Who will retire first? Who will retire first?
I'm going to retire
Because you are senior.
minus of the meeting, page number 80.
Now we get hold of you. Every cases you are relying on the state is relying on a decision of a division bench. Saying that when post is personnel, there is no question of promotion. You cannot have both the standards, both promotion will go. Or you'll have to explain us why. Yesterday we dismissed a writ petition. You relied on this judgment, division bench judgment. So it is binding upon us. What is your stand on affidavit? What are the criteria? You are not, you cannot do like this until and unless you have criteria. Your DPC is there. Whims and fancies. Is that it? Yes, private respondent. Tell us what is your stand. We know that. We know that.
Promotion was given to me.
Very well. You are very able officer,
And my
able grade 4 employee, so you have been promoted. There is no problem on that. What is the criteria or rule governing the field for promotion? Or the executive officer will decide, no, this time we'll give promotion on the basis of performance. So he is performing, will give him. Next year, no. He is a senior. So let us give the senior.
I want to go to the rule they have relied upon.
Go to the
Rule. That rule is they have annexed.
who prevented you into go into the rules
Yes, okay.
since 2018?
Rule is they relied on it. I want to go to that rule. Okay.
So you have not gone through it.
Okay.
Matter is fixed today for admission.
Yeah.
And you have not gone through it. We'll record it and we'll say that we will not give you any hearing. Okay, take your seat. Yes, madam. Huh?
Running page number
80?
82. Eighty
100? Only 82.
written as
79 is the order promotional. 81 is the order, and 82. Minutes of the meeting of the selection committee for selection of candidates.
petition on
Action letter is it's a letter from the Under Secretary, the Director, Diary Development Department.
Which one? Which one?
Annexure 1 of our affidavit. Which number is not listed.
Affidavit.
Okay, but which number is not listed.
Affidavit filed by Horen Buragoy. Page? Annexure 1.
The Annexure 1, the second page.
Yes.
I read Lordship. With reference to the letter on the subject cited above, I am directed to inform you that after regularization of service of WCN MR workers, incumbents concerned are eligible to get all benefits, including promotion as per prevailing government policy, rules, acts, instructions, etc. And if necessary, by issuing associated OM or executive order.
Okay,
What is
fine.
it?
You have taken a policy decision in your department that they will be entitled. But what is that policy? What is the rule? As per prevailing policy, rules, acts, instruction, etc. So therefore, ministerial rule will be applicable, though it is not in the schedule.
Lordship, that is why I am going to that particular route. So 2 minutes ago.
So ministerial rule is applicable.
Yes.
What is the prescription of ministerial rule?
That is the route.
Hmm.
I am going.
What is the prescription?
Lordship, in that particular rule 10(3) of Assam Directorate Establishment Ministerial Rules 1973.
No, we know that. What is the prescription regarding grade
Yes,
4 to
Lordship.
grade 5? Tell us that.
That rule was amended in 2016. And the amended part I am going to read.
Hmm.
That-
Qualification.
Lordship.
Qualification.
Yes, Lordship, qualification
And what is her qualification?
Same qualification.
we are same. Lordship, kindly
Lordship,
let
in
me
the
read
addition list,
particular rule
my name
for a minute.
Hmm.
The amended part of Rule 10.
Hmm.
In the principal rule in Rule 10, for the existing sub-rule 3, the following shall be substituted, namely by selection on the basis of suitability from among the grade 4 staff of the office who possesses a bachelor's degree from a university recognized by the government and also possesses such other qualification as laid down in sub-rule 3 of Rule 12 and have rendered not less than 7 years of continuous service in the office on the first day of the year on which the selection is made.
So criteria is 7 years, benchmark qualification,
Yes, Lord.
graduation,
Yes.
and suitability.
And suitability. Let's see, now my humble understanding is
Now both are graduate.
yes, both are
Both
having
are having 7 years of experience.
yes, both
Now
are having
how the suitability is to be determined?
yes, sir. It is to my humble understanding, it is on the basis of performance. This is my understanding.
Performance in what field?
same duty they have
Performance and SCR
expressed they have communicated
special report. Yes.
Where is the minus of the DPC?
page 80 to 91.
Yes.
82 not.
Yes, page 82.
Which one is your?
Page 84.
84.
84.
At the bottom.
In the minutes of meeting, they have not put any remark.
Where 84 subordinate. Where which table? 84 third table, second table. Huh?
Third one, Lord, bottom.
Yes, it is
Wait. Let me read this. What is the name of the petitioner?
petitioner Arun Chaturvedi.
No, respondent.
Nogen Talukdar, second one.
What about Horace sir?
Red sir. District of Nagaon.
But it's general, all over Assam. Produce the DPC report, DPC record. No, we understand. You said that we have considered everything. How have you considered? Where is the SCRs? What is the special report? How have you had special report? It cannot be like this. Because DPC, there is no analysis in DPC. There must be some recorded thing that these are the comparative. This madam's client is no, his SCR is not always good. You must have a comparative thing. Whims and fancies. Yes, madam, when? The matter pertains to promotion. Claim of promotion to the post of junior junior assistant. Full stop. The claim of the petitioner is that he is much senior to the respondent number 4. Respondent number 5. Respondent number 5. And respondent number 5. However, ignoring her seniority, 5, though they are otherwise equally placed. The DPC meeting reflects that recommendation was made on the basis of service records, gradation list, special reports, etc. However, the minutes of the DPC is absolutely silent as regard the evaluation of such criteria and their determination that the respondent number 5 is a better candidate than the respondent number 4. That being the position, the learned counsel for the respondent number 2 shall produce the DPC record pertaining to the promotion by the next day fix. When will you retire? Next month, March. Will give you all notion and leave and type. The petitioner has expressed urgency that for the reason that the petitioner is retiring on 31st of March. Not sure. Or already retired.
No, not listed.
In the month of March. Let this matter be listed on 5th of March. Name of Madam MM Kotoki be reflected in the process.
Okay. I have yet to get the certificate of okay. And what you want is this junior assistant post is for subordinate.
Your case is that under the schedule of that act, Dairy Development Department is not there. The directorate is not there. But you have taken a principal decision that existing rules shall be applied. If existing rules will be applied, then according to it, that should be the said rule.
Yes.
But we will also look into, on that day, don't say, oh, I am not ready with this point. Ready with all points. We may ask you, what is the appointment regarding Agriculture Department from grade 4 to grade 3? Why should you go to the subordinate if Agricultural Department is having different set of rules? You are under the Department of Animal Husbandry. What is the rule holding the field in animal husbandry? Don't say on that this was not the question on last occasion.
Yes.
Why should we go to the subordinate if there is a specific rule how to get promotion, that this is the direct recruitment, that 25% is for promotion from the grade 4 to sectional assistant, then and this should be the criteria, should be seniority. Why should we go to that then? What is your case? According to you, what should be the rule?
Senior,
From which rule seniority? Huh? Okay, no problem. Judge, one judge is sitting here. He will do his homework. Okay, you need not. You can keep your files here and go home. Yes, next case. Hmm. Huh? Okay. Left the court due to illness. Whether it's like that people should be ill in the second half after taking the ticket. Isn't it? But we don't have that luxury to be ill. Oh, that's why he's ill. Compassion is the problem. On the prayer of the Learned Council for Habitation, list of the colleagues. Termination.
Termination during probation, and after verification of antecedents, it was found that he was involved in a criminal case, and later on that criminal case culminated into a conviction. He was involved with Arms Act case. Has filed the
According to High Court.
Yes, he was employed as peon of district and session judge Bhima Asaf.
None appears for the petitioner and
Last
all,
occasion also
none
found that-
did represent the petitioner on 13/10/2023 accordingly. Though Mr. H. K. Das, Learned Council representing the respondents are present. Full stop. Comma, this matter stands dismissed for non-prosecution.
Highly.
Yes, Samwa.
Lord, I'm not sick.
Not
Though it
sick.
is- Though it is a
Yes,
compassionate appeal. I have not gone through the depth of your case, my lord. The only thing is that my learned friend- Yeah, it was, my lord, the affidavit says that it was considered, but we were not communicated. The only request before your lordship to place the record.
Dismiss many cases.
Let the record be placed, my lord, that it was not. And apply a copy.
2013.
Huh?
It was rejected on 2013.
But it was not communicated. How can we know?
Start of 2012. Rejected in 2013. Remains.
Have you filed an affidavit? That is on record. That is there.
There are 4.
That is there. To file a reply.
No, well, that records which that they consider the minutes of the meeting, let it be produced.
But management meeting is not here.
Not here, not in any.
Bring that.
Well, this will serve.
Okay. The claim of the petitioner for compassionate appointment has been rejected by the district level committee in its meeting held on 14/3/2013. 14/3/2013. Such facts has been disclosed in the affidavit filed by the additional deputy commissioner. Sonitpur or what?
No, Kabul Metro.
Additional deputy commissioner, Kamrup Metro. However, the decision is not part of the affidavit. Mr. Samwa submits that in absence of such minutes of the meeting, the petitioner even is not aware, that is not in a position even to challenge such minutes. that being the position, Mr. Parajoli, learned counsel representing the additional deputy commissioner, submits that he will produce the minutes of meetings of the DLC dated 14/3/2013 on the next date fixed. Next date fixed. Accordingly, next date fixed. Accordingly, please this matter after 4 weeks. Okay, give it. Date is a risky thing in comparison. 13th of March, 2020.
Oh, right.
Yep.
Yes. My lord, affidavit, what is the issue?
Termination of
Termination
in probation.
in probation.
Mm.
What is the reason?
One is medical reason.
Unfit,
Colorblind.
colorblind. Any review?
No, my lord.
Did she prefer for any review?
Yes, my lord. Review has been done.
Review has been done.
Yes.
Now, review also rejected.
Yes. That is also by
But if there is a recent judgment which says that court should not sit over this, any disparity between both of these. What is your ground? That's a huge list. You want to finish it up, everything. What is her case?
Our
That
case
she
is
got
not-
a
not-
different report.
No, that is not her ground.
What is?
His ground is that under 26 for that if he has been targeted at 26. That is not that is in as per law 26. That is not that their ground is not on the
On the
conformity of
the learned counsel for the petitioner. You are already out of service.
Yeah.
You should have urgency. After 5 years, you will say, we do not know whether you can even carry the gun. This matter should be decided at the earliest. On the prayer of the learned counsel for the petition, learned counsel for the petitioner, grace for an is granted 4 weeks time to file the reply affidavit. Please accordingly. Yes, madam.
My lord, affidavit is not required. I will just put
See.
two things and I will dismiss the case. Synopsis, my lord, second line, corner one date, my lord, 23/5/13.
Today I will not dismiss anything, any further.
Oh. My lord,
You do something, give these people that additional pension and all.
no, my lord, he is not eligible for that. That is covered. My lord is passing order. I'm just, that is what I'm saying. Date of expiry is 23/5/13, my lord. And now, my lord, page 12, the affidavit. In 2019, he was 23. So if I go back 10 years,
Because minor.
he was 13 years. So he's not covered by lord. My lord's order, RE 10, Person State of Assam 2930 of 19.
This you will have. This is a wrong judgment. Passed by me.
There is similar judgment by a coordinated bench. Tapun to kiya. My lord, he was actually he was minor man.
When died?
13. So in 2019, he was 23 years old.
When rejected?
no rejection record. I have read RTI 10 reply. Page 26.
What is the reply?
Page 20.
Mm.
Right.
was considered the second part. Lack of vacancy.
The prayer of the learned council put a petition thus cancelled. And peace the floor.
Yes. It is a lot set of I think. We have the philosophy of the work the price of the peak department. But what happened, we are not promoted, we're not doing the promotional benefit matter, not promote. During the pandemic,
Promotion from Khalasi to what?
customer section assistant, plumber, pump operator, like the support.
They are not confident. Your case is not confident.
My lord, what happened, my lord, during the pendency of the writ petition, my lord, they have promoted some petitioners. I am giving, my lord, the serial number. They have promoted.
Where is the impugn order?
Impugn, my lord, page 75, this is speaking order.
Now you are still working as a Khalasis.
Yes.
Page
75 is true.
75 is a speaking order.
Yes. Okay. The end of the department is that, my lord, as they are ex-cadre candidates, so they are not entitled for any promotion. This is the standard. In that regard, my lord, my submission is that, my lord, their stand is not uniform in respect of all employees like similar categories. They have promoted even the petitioners, some of the petitioners have promoted. Their stand is not uniform for all. Petition number 5 promoted, 14, 15, 19, 20, 23, 24, 26, 27. This person is promoted. Some of them are retired also.
How they have been promoted under what rule?
Because, my lord, they do not follow any rule, my lord. They follow some executive directions of their department.
What is that executive direction?
Executive directions I annex, my lord.
Yes.
Page 28. 28 is the type of 1. Then annexer 1B, page 30 is another. And the annexer 2, page 33. The draft rule, this is not notified, but the draft rule they follow like executive.
Where is the consideration of the other? They were along with you. Your name was also considered.
Consideration,
Or-
my lord,
Huh?
we have approached this level court for taking before the DPC for consideration of our candidature for promotion. That is our main.
So it is not that you are aggrieved by somebody else's promotion.
No, not right.
Your case is that our cases are not being considered. This is your case. Now, what is their stand?
Their stand is, my lord, we are not at all entitled for any promotion. Because we are acted. We are not under
In
any.
view of division
cadre.
bench judgment.
Yes, division bench. But on the other hand, my lord,
Where is your regulation, order of regulation?
regulation, my lord, in fact, here, 1, page 20.
Your regulation is grade 4.
Grade 4, grade 4.
Where is that Khalas regular? Where is your regulation?
Page 22 onward.
Page
25.
how you address division bench judgment?
Judgment is against us, mother.
So therefore, how you distinguish that your division bench judgment is not applicable?
Similar, Malad, one case is dismissed by the Honorable Single Judge Malad earlier. And against that, Malad, the presently one writ appeal is pending. It's not yet taken.
Where is that order?
That is writ appeal is under consideration, not taken up for. That is clear.
What is that order passed in? Who has-
Order in the light of the division bench judgment, Malad, that it's data, Malad.
Leave the cow, you know, but where is a single judge's order? Similar person's case dismissal.
My lord, it's not like he might.
Oh, take your seat.
Third round of
Take your seat for a time being.
There are get the lordship, but there is no stay order about it. It's a
Where is that order? Give us. We'll postpone its sign till division bench judgment is passed. If they're unnecessarily wasting time
that writ appeal is in the hearing list, my lord.
whatsoever,
I'm
do you want that I say that this is also dismissed, go to division? Let us wait for a division bench judgment. If you propose to say, so your opening argument should be similar cases ought to have been similar cases dismissed, so let this matter be adjourned. In the meantime, people are waiting. We have spent 7 minutes time. Who will compensate? Give us the judgment. You are not ready with what is necessary.
Mamari, but I'm giving the order.
Where is there? Giving the order. I think you all suppose that we are not aware of the judgments. Give us the mobile. No, where is the single judge's order? Give the single judges. We'll say that this, okay, give us. But subject to correction. I had a different view. And this is binding up. I have a different. Once you bring a person to by a regulation, he is a regular case. His post will abolish when he retires or dies or relinquishes. But can you deprive a person after regulation from the promotion? What is the law behind? Because of a line you are writing that this will be personnel. What do you mean by personnel post? Post is personnel. So is it a deprival from the, is it not engendered by virtue of regulation?
There's no cater.
No. What do you mean by regulation? Bringing the person to the government fold. So if he is a government employee, his service will be considered by the, is be governed by the rule. If he is governed by rule, why will not get a promotion? How can you, it says that consideration promotion is a fundamental right. Time and again Supreme Court is saying. We know, we are part of this litigation. We know that. Mr. Purkashta, Learned Counsel for the petitioner submits that similar writ petitions involving similar issues has already been dismissed and matter is pending Dismiss or allowed?
Dismiss, sir.
Then why do you have filed appeal?
Appeal will be asked.
Okay, allowed, dismissed. However, appeal has been preferred before a division bench and matter is fixed for hearing at this stage. In few, just tell us, this is now locked again. In writ appeal number,
172 of 2020,
matter is pending for adjudication in writ appeal number
172
of
2020.
up to 2023. That being the position, registry to list this matter after final determination of the aforesaid writ appeal. You thought that now sitting person in division bench express some opinion, so therefore that judge can overrule the decision of division bench sitting singly. Then why you started arguing?
I have started arguing only to apply the
What you need to apply? You need to say that might be similar cases dismissed now pending before division bench. Yes, next case.
My senior is the
But he's seeking the benefit of Upen after the petition.
Okay, do you think that he entitled?
Lord, that case, that issue can be verified by the commissioner after going to the service.
Current counsel for the petitioner seeks for an adjournment. Prayer stands allowed, list after 3 weeks. Yes, Mr. Rahman, you are sitting.
Yes, Lordship, I am sick, but still that I have complained that he was in hospital last October. Lordship, it is a case of the declaration and pension of the town committee, and so it is already there's a direct Lordship. Kindly, I like to refer this order dated 19/7/23 in the file. Still today, finance department has not produced the affidavit, nor they are producing record. 19/7/23. Well, not. Then thereafter, 7.
Now, Borpujari, she will do that.
Then 11/8/23.
Yes, ordered it.
Ordered it first 19/7/23.
But these instructions I have received, my lord, it is dated 11th October 23.
Oh.
Thereafter, this matter has not been, my lord, taken up by this honorable court, so I could not have placed the instructions, my lord.
Affidavit is required because on file.
These are the employees of municipal board.
Municipal court.
Now, their salaries are being paid by the municipal board.
No, but sometimes they cannot.
I say some grant is municipal grant and constitutional under consolidated fund and all. This is required to be.
Absolutely.
Isn't it?
Yes.
Because it's a very important organ under the scheme of the constitution itself. It constitutionally provided certain safeguards.
Chapter 9A of the
Ah.
Constitution.
That it cabinet is not also taken for regulation of the fund. And it is already approved in file number 129. Approved on
Now
21.
you want to regularize this.
Yes. Now, my lord,
For cabinet decision has already taken.
Second,
Taken here, page 100. Lordship, I here in my petition I have annexed the cabinet. Page 100 in my. I think 2, 4, 5.
in fact, this resolves your issues. That giving grant in it, not getting salaries once. I think that's why cabinet has taken this
cabinet has taken this decision.
on principle. But
Yes.
what happened thereafter?
Yes, my lord, if my lord is perusing page 100, My lord, this is the extract of minutes of the cabinet meeting. My lord, kindly see, my lord, I am reading it, my lord. Recommendation of the Committee of Group of Ministers of Finance report and the supplementary report on the fourth Assam State Finance Commission on staffing pattern of local bodies, Panchayati Raj institutions, urban local bodies and Guwahati Municipal Corporation and provincialization of service of their employees. Now, what has been approved? Number one, the staffing pattern of PRIs will be examined by a committee to be constituted.
Okay,
by-
fine, fine.
Yes, yes.
That
Now-
part is there because ultimately the staffing pattern is done.
Yes.
Provincialization will not be.
So,
This is the first stage.
Yes, first, then second, my lord, the proposed staff strength and to provincialize in principle 5170 posts for 5 categories of QLB, including regular scale of pay for sweepers, along with corresponding scale of pay recommended by the fourth Finance Commission. Then, my lord, proposed staff strength. Then, my lord, number 4 is important. Salary provision for the provincialized ULBs, including.
Okay, what happened thereafter?
Yes, now thereafter, my lord, if Lordship is perusing my instructions, Lordship will kindly see, my lord, I am reading it out, my lord. What is the role of the finance department here? With reference to the.
No, we are not on roll.
Yes.
We are on whether you will apprise us or Parajuli will apprise us or Thor. This is
Yes.
not the issue.
Yes.
Issue is if you do not dispute that this is not been done, page 100. Now, page 100 is not a final conclusion.
Yes.
There are in principle decision is taken.
Yes,
Until and unless a notification is issued,
my lord.
that cannot be said to be a
Order.
decision
Yes.
or order.
Yes,
Now, this is a in principle decision is taken.
Yes.
While taking in principle decision, they further want to have clarification that what should be the staffing pattern and how it should be regular. For that, Chief Minister was supposed to have a committee.
committee.
Now we want to know how this matter has progressed.
Yes, now.
Not only finance.
Yes, my lord, since I am representing the finance department and there were directions from this honorable court to apprise this honorable court about the stand of the finance department. So this instruction at paragraph 2, my lord, may I read it, my lord?
Yes.
However, as regard the proposal for provincialization of ULB employees, keeping in view the present resource position, Finance Economic Affairs Department with due approval of higher authority, had endorsement dated T5/2016, stated that the proposal for provincialization of ULB employees may not be acceptable for the Finance Department for the following reasons. Number one, if the government takes decision for provincialization of ULB employees, there is every possibility of initiating such proposals from PNRD department for 23,790 employees and for PRIs and GD employees, so and so numbers of GMC employees. Then, my lord, number 2, since the state government gives devolution grant to the local bodies in pursuance of recommendation of the State Finance Commission, there is no logic for provincialization of the employees of the local bodies. Number 3, as the 73rd and 74th Amendment of the Constitution of India have accorded separate status of government with specified powers and functions to local bodies, provincialization of service of the local bodies runs.
No, that we understand. This is the view of a finance department.
Finance department.
But finance department is also part of a cabinet decision.
Yes.
Isn't it?
Yes.
So,
Now, my lord, now,
cabinet has taken a decision. This is the opinion of finance.
Finance.
That may be considered by cabinet, that
Yes.
may be accepted, that may be
Absolutely.
overruled.
absolutely,
Ultimately, the highest executive is the cabinet led by the Honorable Chief Minister.
absolutely.
Isn't it?
Yes. Now,
Some joint secretary's opinion of finance department is having no value before the cabinet.
absolutely.
It might have a value.
Yes.
Might have a value, but cabinet may reject it, cabinet may accept it.
Yes. Good.
But the cabinet meeting says that
Well,
in principle something is done.
Yes.
Now we want to know whether that decision is reversed
Yes.
or not reversed.
Yes.
We cannot say no, cabinet has taken a decision, you regularize.
Yes. Yes.
We cannot.
Yes.
But we want to know, they have come, see, this is our position, you have taken a decision,
My lord,
do something,
my lord.
isn't it?
Yes, my lord.
Now who will represent that cabinet?
Yes. Now, my lord, here the respondent number 1, Commissioner and Secretary.
So we understand, your position is clear.
Yes.
This is opinion of the finance.
Yes.
That is neither binding upon us nor on the cabinet.
Yes, lord.
So this is your opinion, nothing more, nothing less.
Possible
It is not a policy decision, it's an opinion.
Yes.
Okay, fine, let the opinion be there for the time being.
Yes.
we cannot judicially review that opinion.
My lord,
Of course, cabinet can take a view or call on that.
yes,
That is the prerogative of the cabinet.
Yes.
Now, who will represent this cabinet?
my lord, precisely here, my lord, the respondent number 1 and 3 are to my lord,
Who are respondent 1 and 3?
one, my lord, is the Commissioner and Secretary, Municipal Administration Department. And
Whether chief secretary is a party.
no, the Secretary is not a party.
Cabinet decision.
And
How a department can make a comment on the.
May I speak? Lordship, let them file an affidavit with one record because as per
No,
my
who will file affidavit to what?
finance, because all the time, taken by the finance department. That finance department is not approved, that they say.
No,
In
no,
respondent one,
Mr. Rahman.
But-
They may say anything.
but they've
They
come
may
with
say
record.
anything.
They've come with record.
They may say anything. That is not the issue in this case. Their statement will be relevant when there is value of that. Isn't it? In this case, their opinion so far relating to this issue is having no value before this court.
But this case covered.
See, listen to me.
No, Supreme Court judgment is here. I'm with the, I'm
No, understand.
equipped with the.
Understand. Can we say, forget about cabinet, forget about your finances decision that we are opposed to regularization and regularize? Is it permissible? No.
I can-
This is no. This is no. So your whole case should be the cabinet has taken a decision. This finance say joint secretary or secretary decision opinion, highest executive body is the cabinet.
When that not be finance, but I've approved this file. So if it is decision, then notification, everything has been, that's why I wanted it to. Because that record must be produced. Because they have submitted.
No, no, we want to know from the competent person who can apprise us what
That is it.
happened thereafter.
That is
Yeah.
finance problem.
because
Finance problem. We can, because answer things depends upon the finance department. As per.
So they have said we are opposed.
No,
Then what, how, what can
there
we
is a
do?
formal submission. Let them produce the record. 311030 file is there. I can mention the file number also. File number 12912. That finance department all approved this. All resolution, all finance matter, financial sanction that has been approved in this file. That I can produce the record also. If they can produce the record, if let them file an affidavit
now,
denying all these things, I can prove. And in that
Are you having that record?
record of the there.
You know that you are making.
Yeah, I can collect the photocopy because my client has already collected photocopy. I openly stated this for this.
To give us a copy, we will record it. That this is the document produced, we'll record it. And we'll say that the finance has
Well,
taken
this
an
is
interview, let
all
there
the
be an
time.
affidavit.
my lord,
Give us.
with all respect, my lord,
Hmm.
the prayer here is specific. They pray, my lord, issue direction to the respondents to implement the cabinet decision dated September 2013. Now, Lordship is inquiring what has transpired thereafter. Now, I being not the administrative department, therefore, my lord, the administrative department will be in a better position, my lord, to apprise this honorable court. As to the consequences that took place, my lord, in pursuance of this, my lord, cabinet decision.
Sir Rahman, you ought to have filed this by way an affidavit.
Because I
I
can
was
only
waiting because let them file
Don't
an
wait.
I will counter it.
You have, then they could not even take this stand.
The read petition is fine. We send it to the department. Department
Yeah,
only on the
send it.
basis of the state.
We are not commenting on secretary's opinion.
Yes.
Let me be
Yes.
fair.
And
That may be secretary's opinion. Can that be a decision overriding the cabinet?
My lord, I am not on that.
So that is that having no relevance.
No, my lord, my learned senior counterpart is submitting that we are not producing the record and he has the record and a photocopy of the record.
Where is your earlier cabinet decision? Page 100.
600.
The present writ petition is filed. Issues are small. We are making it big.
Now, whether this cabinet decision has been given effect to my lord, to that extent, my lord, these two respondents.
No, you are not in a position to say. Who are you to say cabinet decision is taken or not taken? You are not representing the cabinet.
No.
Then,
So therefore, my lord, we,
isn't it?
and if lordship desires, my lord, I can bring this instruction on record by way of an affidavit.
That is your opinion. I am time and again saying. If that is been considered by cabinet and accepted, matter as there.
Yes.
We are not here to give analysis on your opinion.
Yes.
That is your views, because finance department is always, they do not want to spend money. Cabinet may overrule. No, forget about this. We have a constitutional mandate. We'll manage fund for these people. That may be the decision of cabinet. Your opinion is overruled. What is the value as on date? Isn't it? Am I wrong?
No, lordship is correct.
Then
Now, I am only, my lord, prepared because to make further submission in view of page 100, my lord, cabinet is.
that
Yeah, I
is
have
fine.
to be
That
fair
is
to
fine.
the court, yes.
That is fine.
Yeah, I have to be fair to the.
That is fine. That is not a problem.
I cannot, my lord, elaborate my submission.
Support of this judgment is the Supreme Court judgment.
Judgment we rely when we are in we are in a confused state or difficulty, that we are not been able to take a call, so we need ratios. We are clear here. Why should we go for a Supreme Court judge? The present writ petition is filed with a prayer to issue a writ of mandamus directing the respondents to implement a cabinet decision dated 4th of September 2013. Full stop. A copy of the said cabinet decision is annexed with the writ petition, which goes the said cabinet decision goes to show that a committee of group of ministers constituted for consideration of such group of committee of group of ministers has submitted recommendations and report on the 4th Assam State Finance Commission on staffing pattern of local bodies within bracket PRIs, capital PRIs, comma ULBs and GMC bracket close, and provisionalization of services of their employees. The Annexure B, the said cabinet decision under item number 10, within bracket within number 10, further goes to show that staffing patterns of PRIs will now be considered by a committee to be constituted by the Honorable Chief Minister. It was proposed to pay regulars. It was approved in principle to grant regular scale of pay to 5170 posts of 5 categories of employees of ULBs, along with corresponding scale of pay recommended by 4th ASFC. Etc. Full stop. However, no affidavit has been filed by the respondents, either respondents, regarding the veracity of the said cabinet decision. Full stop. During the course of hearing, the learned senior counsel representing the petitioner has further submitted a copy of an a resolution, a copy of a decision of additional item number 2. Extract of the minutes, copy nine, extract of the minutes of the cabinet meeting held on 28th of October 2013 at 6 p.m. in the official residence of Honorable Chief Minister, Assam, which goes to show that recommendations of Committee of Group of Ministers on final report and supplementary report of the 4th Assam State Finance Commission on staffing pattern of local bodies and provincializations of their services, provincial of services of their employees have been approved. In view of such, Mr. Swencho, learned senior counsel submits that even after approval of the cabinet, no further course of action has been carried out by the state. Full stop. Mr. The petitioner is permitted to bring the minutes of the meeting dated 28th of October 2013 within bracket supra by way of an affidavit in opposition. Now, who will bring the instruction? Or who is representing the department?
Not affidavit is appointed.
By when?
All right, I will do.
To Mr. Borpujari, on the basis of an instruction received from his client, that is that joint director finance within bracket economic affairs department submitted that the finance department is opposed to such regularization. However, this court is not inclined to consider such a stand at this stage, in as much as the aforesaid is an opinion of the joint director, not a decision of the government. Therefore, the government is to clarify whether the proposal, whether any further course of action, whether any course of action, any further course of action has been taken in terms of its cabinet meeting held on 4th of September 2000, in terms of the in terms of the decision made in the cabinet meeting held on 4th of September 2013 and in cabinet meeting held on, what was the date? Cabinet meeting held on, just now you have given me the paper. Cabinet meeting held on 28th of October 2013 by way of an affidavit. Full stop. Mr. Thor, learned counsel, submits that he may be granted 2 weeks time to file such affidavit or to apprise this court. 3 weeks time to file affidavit and to apprise this court regarding regarding any finality as regarding any course of action that has been taken pursuant to the aforesaid cabinet decision. Please this matter on. These are simple issues. Or simple, if cabinet says we have done it, you say no, finance has opined subsequently, our financial condition is not that, already consolidated grant is there, let them run there. That can be a decision. Then Mr. Rahman will be in a position to challenge it. not challenge it, accept it. For this matter is pending since 2009. A copy of the, then again it will, Mr. will apply tomorrow. Mr. Thor is permitted to obtain a downloaded copy and forward the same to the competent. Okay, list this matter showing details that good register to list this matter showing name of Mr. R. Learned Counsel. These matters need not be kept pending for 2018, and we need not burden Mr. Borpujari to bring such opinions, which are having no value. He has no way out, courts are directing, give something. So he's bored, what to do? We do have objection. Matter is there. What will he do? Cabinet may accept his opinion. Yes, finance is correct. We are not in a position.
I'm so obliged.
Usually 5 and 2, that's correct.
Huh? We do not know. We cannot presume things. Yes, next.
I'm obliged.
What are these?
This petition has been filed by the Qatar Paper Mill Supervisor Association and Officer Association and some of the employees, claiming salary for 30th month or 32 months. The 3 bunches of petitions are there. Two is from Qatar and one is from Monaco.
Who will pay the salary?
So far as salary is concerned,
To whom will issue the direction? Tell us first. Because we must know that our directions are implemented. To whom will pass this order?
but we have received by a memorandum of understanding the petition. Some government has come to an arrangement with from their realization, we have received some amount, some profit. And now
Is a company?
company,
Liquidation under IBC?
IBC.
Huh?
Yes,
So you are having a fast start. Have you filed anything before the IBC?
no,
After notice?
the liquidation process started on behalf of some of the creditors.
When it is a liquidation, maybe creditors. There are certain procedures. Secured creditors, salaries, arrear of salaries, pensions, everything. That will be taken care of by the liquidator. Read court has no business. Close it.
So far as PF is concerned, my lord, we have not the PF at the last occasion, the central government and the liquidator.
No, PF is something different. Who will pay PF?
But the actuation, the PF has been deducted from our salary. Has not been deposited for the offers. Now, so far as PF amount is concerned, there's a huge amount being accumulated in the fund. Those PF amount has not been released yet.
So PF commissioner will come and say not deposited. So they will say we are taking a criminal action. Now what will happen regarding this PF liquidator will have to do it, because this was a responsibility of the company to deposit. Now company is under liquidation. So one amount, the PF commissioner will go and say, see, this is our due. So that will go, liquidator will pay to the PF commissioner, then only will get. This is the procedure, subject to what you say. So,
the same issue, the Supreme Court is same issue, the PF entitlement. Supreme Court has held that it will go as per section 34 of the Act. The IBC says
without going to the Supreme Court judgment, we have said it, isn't it? Now, what to do in this case? Close it. Heart, Mr. Vishwas, Learned Counsel for the petition. It is difficult to further comment on liquidation also, because there are some issues. Of course, your right will be protected. But when the liquidation notice, liquidator issues a notice under IBC, you need to raise your claim. Let's see, this is our due. Maybe as an association, no problem on. But if you are not raised, Think over it. You're not closing like this because at least PF is your PF salary, everything is your right. You are representing whom? Who are they? What do you say? You are here. What? Why should you? What is their? What is your stand? Have you taken cognizance of these people? Their claim. Hmm. Distributing. And what about you? Have you received any instruction from your client?
So I have just so far the arrangement of the Assam government liquidity transfer from that amount have to them, not from the liquid.
Liquidator, Assam government has, why Assam government will go to the liquidation to a company of belonging to the Union of India, more stakeholder, because the Assam government in the IBC proceeding they have acquired this property.
Yes, sir.
So therefore, the amount due is to be paid and determined by the professionals, because the professionals will decide, then also liquidator, isn't it? So IBC professional has determined these are the amounts. Thereafter, amount is determined, then Assam government has paid, then it was handed over to the Assam government. Now the liquidator will pay from the pocket of Assam government, isn't it? So from proceeds of sale, because Assam government is not a grant in it, they have acquired the property. Now they will do whatever they like. So now what to AIDC has acquired? AIDC. So what is your stand? Yes, Mr. Vishas, are you aware that your clients are being paid money?
So I am aware the clients are being paid money out of that arrangement.
Okay.
The
Definitely out
government
of
has
that
got-
arrangement only.
Because the sale proceeds were not that enough and they were not being able to pay to all the creditors as per the lease. As per the act. So far as our clients are concerned, but we have received some perspective. So far as PF
Now, so therefore, this proceeding, we cannot pass any effective order.
Yes, perfect. So far as PF is concerned, my lord, if any instruction comes from their side.
Just think of it.
Yes, sir.
No, liquidator will have, because in IBC code so far relating to this PFL. So because this is also a due not to them. This is a due to the PF commissioner, isn't it? PF commissioner will say, give me. Then from this purchase, an amount will be given to PF commissioner. Then only they will make a claim before the PF commissioner. That is the procedure. You have instruction. We're just adjourning this matter till Friday.
Perfect.
Now you have this specific instruction. What is the determination so far eliminating the PF? Okay, we'll not throw them out like this. Please this matter on Friday. On the aforesaid date, the learned counsel representing respondent number 224 shall apprise this court regarding the status of liquidation, more particularly the payment made to the petitioners plus employees of Assam Kasar paper.
Right.
Banglo Pion. Banglo Pion. What is the judgment, Banglo Pion? You are not aware? You have the Banglo Pion judgment by my Lord Justice Gogoi as then. How to accommodate this Banglo Pion after retirement of the officer Are you aware? Mr. Parazili, learned counsel for the respondent press for and is granted 3 weeks time to file affidavit. Please defer. Okay. What happened to her? Huh? B. Bhuya, senior counsel. What happened? What emergency condition? Tell us. Not for this adjournment. We want to know what happened to her. Submitted that Ms. B. Bhuya, learned senior counsel, who learned senior counsel is having some personal certificate accordingly. Prayer for adjournment is made. Prayer stands allowed. Please stop. Call, will you please?
Matter is being led by senior counsel against the case. Okay, but
Any case logic, this has become instructive. This person is seeking some review of the service conditions, and the person is now out of that.
Let him have the satisfaction of
Yes, yes.
presence of Mr. Kench.
Yes.
Alright.
List this matter. Divided motion. Hard support.
I do like.
Mr. Architect Chaudhary.
Anganwadi issue, my lord. We have filed an affidavit.
Okay, today is 4:15. Has agreed to list this matter. Non-appears to the petitioner at all. List this matter after 3 weeks.
My lord, they are yet to file the affidavit.
What is this?
My lord, this is a case against, my lord, first is about suspension with regarding to, Professor Ranjit Tamuli, who was acting as a vice chancellor in the Dibrugarh University. In this, my lord, we were giving a protection for cross-examination during the inquiry. The second writ petition, my lord, that is 3814, my lord. We have challenged the inquiry committee. And in the fourth, my lord, it's about the impugned inquiry committee, the second revised inquiry that has been given to. And my lord, thereafter, there is another one which we have filed, which has not been tagged, 8177 of 2022, where he has been removed. But because of the first case, my lord, that is 2985, we have been protected because there is a final order that states there that any out that in nature of the purpose of passing this clarificatory order, an action taken by the universe will be subject to the final outcome of this dispute.
Okay, when?
My lord, 2 weeks time may be granted, my lord. My lord, we have to file affidavits in all the petitions, my lord.
Have the record. This is departmental proceeding.
My lord, 2 weeks time, if lordship permits or
My lord, this will be the last chance, my lord, from 2021.
What last chance? We are not being able to finish the list. How can we say that last chance?
My lord, from 2021, my lord,
Still
my
it's
lord,
far on us. Yes,
my lord, orders has been, 2 orders of my lord itself.
we understand that.
My lord,
Mr. Pisamal and a counsel for the petitioner submit that another petition being
8177 of 2020.
WPC 8177
Of
of
2020.
2022 need to be taken along with this writ petition in as much as the issue involves are similar to the present batch of petitions. Such prayer is not objected to the guardian for the respondent. No affidavit has been filed till date, though this matter is pending since 2021. In the opposite perspective, MSR Borua, learned counsel for the state respondent, submits that she may be granted 2 weeks time to file further, 2 weeks further time may be granted to file application. Prayers that's allowed, list of the application.
File an affidavit, but the copy has not been.
Who filed addition?
Yes.
Okay. Additional affidavit in opposition. Who filed? It is submitted that Guwahati Municipal Corporation has filed an additional affidavit in WPC.
The first one.
5090 or 53231, 5310.
Five.
Yeah.
No, file who?
Filed in Lordship 5090.
5090 2021.
Yeah.
And this same will cover the pleadings of WPC 5310 2021. Mr. Nayak submits that he will serve a copy of the affidavit to both the learned council. First of all.
He has already been given.
Okay. Okay, we'll just
Lordship.
okay. The learned council for the respondent petitioner submits that they may be granted some time to go through the same and to respond if so advice. Accordingly, matters gets adjourned and we list it. After 3 weeks. In the meantime, response verified. Yes, Bothagur. Nothing to be happened today.
To disciplinary proceeding. In fact, your Lordship, we have filed our reply, your Lordship, their affidavit in opposition, your Lordship.
Remove from
Remove from service.
which post?
We are holding different posts, your Lordship. The sectional assistant one petitioner is.
Why remove?
Your Lordship, for participating in the demonstration. Matter may be passed over for the. Your Lordship, fixed on 15.
That will be decided by Madam. Due to paucity of time, this matter could not be taken up. Please this matter on 19th.
Then your Lordship.
21st.
Obliged.
What is this IA? Huh? On the prayer of the learned council for the petitioners, matters can adjourn and be listed on the. Obliged. Mr. Nayak, today is no scope. We have specifically listed your name. Where is the order? Okay. But where is the order, madam? Order? An order in the repetition, order of the repetition?
This Lordship is in.
It is not a contempt.
Is the con.
Where is the order, please?
Order is in page 8, Lordship, and the portion is on page 9, Lord.
What happened thereafter? What do you stand, Mr. Rana? Okay, please, you just go through it, possible.
Yes, yes, Lordship, that last occasion I have.
Is it rejected?
Yes, Lordship, because
It's just that regulation is
this
not.
is in page 13 of the contempt petition, Lordship.
None appears for the petition.
Petition.
Not today, not today. We'll do it in a proper way. Because this order is a specific order.
Yes.
Hadn't been consideration and all that would have been a specific create supernumerary post. So whether government has created. Okay. So you may say that no, this order is not implementable. You may consider, but whether that stand is there. So it's a specific order. That's why we asked you. Court also asked her.
Yes,
She is
Lord.
not otherwise in the case. Court has asked
Yes,
her, requested. So as a finance, that may be necessary. That's why I have asked you to reflect that your name. She is there already. Okay. So we are taking it this matter, list this matter on 12th of in the hearing.
Like